Mr. Semenya.
Good morning, Chair and Commissioners. We have today sat down for the cross-examination of Advocate
Yes. Thank you. Mr. Vani, that is confirmed?
Yes, I confirm that, Commissioners.
Yes. Advocate Simelane, you are reminded that you are still under your former oath. Thank you. Mr. Vani?
As the Chairperson pleases. Chairperson, Commissioners, before we commence, just to give you and the parties an indication of the organisation of the bundles. We did circulate a main bundle yesterday morning, and then I think late last night we also circulated a supplemental bundle of just a handful of documents. We thought we'd keep them separate so that there's no confusion about which bundle to use. And we have provided one extra document in the form of a letter, which I believe is a loose document before you, which we'll come to in due course. And I understand that the witness also has copies of these bundles before him.
Yes. Is the supplementary bundle the one that starts at page 715?
I believe that is the case, yes.
Thank you.
Chairperson. Advocate Simelane, I first want to thank you for the cooperation that you've provided to this commission, and also for making yourself available for cross-examination this morning. It is appreciated. Thank you. Just to give you a sense of how I'll deal with the cross this morning, it's essentially broken up into three parts. I'm going to take you back to your main statement that you filed with the Commission in October last year.
Yes.
And we'll deal with matters arising from that statement. We'll then move to your supplementary statement, which you filed, I believe, in March of this year.
Yes.
And then lastly, we'll deal with your evidence in chief, and we'll make certain references to the transcript in that regard. And then there might be other questions that I might have to come back to. So it's essentially in 3 or 4 parts. So let's then turn to your statement of the 27th of October 2025. And Commissioners, that's in the bundle at pages 23 to 43. And if we can jump immediately to paragraph 16. And you'll notice, I'll just wait for you to get to paragraph 16.
Yes.
And in that paragraph, he mentioned that you've attempted to locate 2 officials that worked in the TRC unit in the department, but without success. He mentioned that they left the department some years ago, and so because you weren't able to contact them, you had to proceed largely from memory. Are you able to give us the names of those 2 officials?
Yes, I remember one, Dr. Khotso Devie.
If you can raise your voice,
Yes, Dr.
Advocate
Khotso
Simelane.
Devie. And the one gentleman, I can't remember his name, but you worked under him. I was going to get his details from Dr. Devie if I was able to contact him.
Okay. And as far as you know, is Dr. Devere still alive?
Yes, as far as I know, he's alive, yes.
Okay, so he could be traced, and we will ask the evidence leaders if they can attempt to trace him.
I had his number, but I didn't have it anymore, but yeah, it's
Right,
traceable.
no, I'm sure it won't be too difficult to trace him. And if we can then move to paragraph 17 to 19, And I appreciate the fact that these different meetings you refer to happened many years ago. But we would like to probe with you the approximate dates of the two cluster meetings you refer to. So, for example, in paragraph 19, in the first line, you say, at the cluster meeting subsequent to the one above, and I'm assuming that the one above is a meeting you reference in paragraph 18. So on the same page, you say, I recall one meeting where he indicated that the NPA was engaging with the police. Am I right in saying that that's the other cluster meeting you're referring to?
Yeah, no, correct. I don't really remember the sequence per se, but what I was trying to indicate there is that the meeting that I referred to in 19 followed the earlier meeting where the debate had actually started about the agenda item of TRC. That's what I'm simply trying to say, that there was a meeting where there was a general discussion. There wasn't much of an issue there, but the issues were introduced. But at the subsequent meeting, there was almost like a follow-up of the issues.
Okay. Now, you don't have the record, so I'm not going to ask you the dates of those meetings, and you've indicated that you don't know the exact dates. But can we attempt to narrow it down to the year in which, or the years in which those two meetings would have taken place?
Around 2006.
Around 2006.
2006, yes.
And actually, that's what I thought, because in paragraph 10, so a few paragraphs earlier, you do mention that you established the TRC unit around 2006 and 2007. So we then assume that these meetings would have happened in the same year.
2006, yeah. Well, it's also because I joined the department in 2005, June, mid-year. So pretty much a large part of 2005, I was just like trying to find my way around the department. I only got properly to grips with things around 2006.
Noted, thank you. Right, then focusing on these paragraphs, and of course this now deals with the meetings of the DG's Justice, Crime Prevention and Security Cluster meetings. Can you remind us why there was a need for the TRC cases and the composition of the prosecution team to be discussed at these DG cluster meetings?
Yeah, well, I think in my last in chief, I did explain how the cluster system works. So if the item is on the agenda of the cluster, its full details are discussed. For clarity, it's basically kind of an oversight of a program. So when you do an oversight of a program, you look at its full details. You don't necessarily have to do anything about it, but you have to interrogate everything about it so that when the DGs then comment about that particular issue, they have to comment on the full spectrum, depending on what they want to talk about. For example, if the curiosity is about the composition of the prosecuting team, it should be, whoever would be curious about it would have to indicate why they're interested in that particular issue. So it could be somebody either objecting to an official consent for whatever reasons that they may have, or it could be about lack of adequacy of the team, which we would sometimes comment on. So it really always more to probe such that when the DGs make decisions which become recommendations to ministers, we all would be able to say we have a full appreciation of what's going on, and therefore the decision is made on that basis. That would really be the reason. It's oversight and it's monitoring of a program.
Thank you. Well, we will return to the question of the composition shortly. But in this case, it appears that the oversight was more about, oversight of the program, but it included oversight of individual TRC cases. Would that have been an appropriate function for that cluster?
Yes. Yes, it's oversight of the program as a whole for general reporting about how it's running. But it would, as in all programs, it naturally does involve the specificity of how the program is being run, again, from a variety of perspectives. I did mention, if I recall, that the cluster has in it an operational component. It's referred to as joints, Joints. So in other words, for the operational programs of policing, intelligence, policing, defense, and so forth, there's a joint part of the cluster that runs that kind of work, and it reports to the DGs. The DGs is more oversight and policy commentary and so forth, not operations. But joints comments on operations. So when that gets done, those are the people who feed to the DGs how the program runs on the ground. So when the DGs therefore comment on the general oversight, but also on the specificity of an issue, it would have received, the team of DGs would have received information from teams like joints and so forth, amongst others. So it always involved even the specificity of a program.
Yes. And in this case, which we will return to later, in terms of specificity, it included the DGs insisting on making a recommendation in each TRC case before it goes ahead.
No, it never got to that stage at all. In fact, that discussion never got.
Yes, we'll return to it. I agree that the DG's cluster never got there because Advocate Picoli objected to it, but we'll come back to that in due course. Paragraph 19, in the middle of the paragraph, you mentioned that it became clear to the cluster that there was an issue relating to lack of coordination between the police and the NPA. So what was the issue around the lack of coordination between the police and the NPA?
What I recall about this is that in the discussion of general progress, all of the departments, mine included, would report in the normal course that there is an interdepartmental task team, the work is continuing, and then other departments would comment likewise. So in one of these instances, the police were commenting that on their parts, they are engaging with the NPA, but there is a dispute between them around sending team members for the reasons that I described. So when we then zoomed on that issue, that when it was indicated that, look, as the police, we do have a difficulty in that we're not finding each other with the NPA on the composition of the teams, and then obviously the debate followed from there as to why, and that's when it was indicated that there were objections from some of the members on the police side and on the intelligence side about some officials of the NPA in the PCLU.
So the objections to the team members was objections to the NPA team?
Well, it was specifically rounded up to an objection. Primarily, it was about Mr. Ackerman.
Okay. All right. Well, then let's turn to that, and that's set out from paragraph 20 of your affidavit onwards. So, just to summarize, paragraph 20, it points out that there was this unhappiness about the presence of Ackerman as the lead person on the TRC cases because of his alleged links to the persons it was alleged were likely to be investigated and prosecuted. and of course he was accused of being an apartheid prosecutor. Let me first ask you, why was the presence of the lead prosecutor on the TRC cases, why was it any business of the DG cluster?
Well, it wasn't the business of the DG's cluster, but it had an impact on the work of the DG's cluster. It had an impact because the program wasn't moving at a pace that would have liked it to move. And the reasons that were given, especially from the police side, is that the National Commissioner was having difficulties with his members. Similarly with the acting head of NIA at the time was having difficulties, at least that's what they reported, with his members who, when they were wanting to put names forward for people that would go and assist the NPA, they indicated that they were meeting some resistance from their own members. They didn't indicate who those members were, but what we understood and made to understand is that there's a reluctance on the part of some of their members to being forwarded to working with the NPA on account of the presence of Mr. Ackerman primarily. It wasn't him only. I mean, they also mentioned Mr. Chris McAdams and Tori Pichodas, but we're able to just reduce the issue to Mr. Ackerman being the one they appeared to have the biggest problem with.
So, as you understood, what was the view of the SAPs at that time, that until the issue around Ackerman had been resolved, that they would be unable to assist?
Well, I didn't say until it's resolved they would be unable, but it just became apparent that it looks like there's not going to be movement on this matter satisfactorily until at least this issue is discussed and resolved.
Okay. Now, can we hone in on the persons at this DG cluster meeting who were unhappy with Ackerman leading the TRC cases, and the persons who described him as an apartheid prosecutor? Do you recall who
Yes,
raised those concerns?
yes, I do. It was the former National Commissioner, the late Mr. Celebby. It was also the late Secretary of Defense, Mr. Masilela. It was also the late Mr. Manzini, the heads of those departments. Well, they were saying their members were informing them that to be the position. But from the way they engaged, I also got the impression that it was also them who had that particular feeling.
Okay. Just to get those names on the record, we have the Secretary of Defense between the years 1999 and 2008 as January Masilela. Is that correct?
Yes.
So he was one of the
Yes.
persons. And then the Correctional Services Commissioner, we have one Linda MT, who was the commissioner between 2004 and 2007.
Yes, yes. But from his department, we didn't get any. There was no issue about them cooperating because I don't think they were involved. But it was just part of the discussion, like other DGs.
Right. And then National Intelligence Service. Are we correct in saying that at that meeting it would have been Manala Manzini,
Yes.
the DG of NIA?
Yes.
Okay. Now, did these individuals at this meeting, did they disclose who the persons were to be investigated with whom Ackerman allegedly had links?
No.
And was any proof ever put up that Ackerman had dubious links with these individuals. I think they were described as apartheid operatives.
No, I don't remember.
And in terms of the accusation that he was an apartheid-era prosecutor, was anything put up to give examples as to how he had conducted himself as a prosecutor during the apartheid days?
No, there's nothing specific, so there's no reference to any case he had done or anything of the sort. The general reference was in his capacity as basically a prosecutor in an office wherever he was. Similarly with Mr. Makadam in that case, I think reference to Mr. Makadam was that at some point he was working in KZN out of Pietermaritzburg. So it was generally information presented as information being mentioned that because of what the members would have been talking to those DGs in their departments were basically saying as their experience or experience of people they knew in relation to those individuals.
Right. But they didn't put up any specific experiences in relation to Ackerman.
No, and the cluster didn't ask for that as well, specifically.
So, am I right in saying that the nub of the issue was that he had been a prosecutor in South Africa pre-94, and that was the issue?
It was a bit more than that. It was that he was a prosecutor pre-1994, but that he specifically worked for the apartheid government in that sense. And we all understood that it was basically put in not a favorable light in that sense.
So the problem you had with Ackerman, am I right in saying that you would, or at least the DG cluster would have had the same problem with any prosecutor who had worked for the apartheid government in the apartheid days?
Well, I can't say it's the view of the cluster. It's the view of those who were involved in that discussion, and that's how they presented it in the cluster. But it was not about every other prosecutor. I don't remember a discussion of every other prosecutor. I remember this discussion being centered around specifically the individuals mentioned.
So the problem we have with that account is that at the meeting and subsequently, those who raised their concerns with Ackerman failed to put up anything specific. They failed to point to the individuals which he allegedly had links with. They failed to point to any specific conduct of his as a prosecutor pre-1994. So certainly from our client's perspective, the question is, were those the actual reasons? Were there not other reasons which bothered them?
Yeah, not as far as I know. None were indicated to us at the time.
Okay, let's move to the next few paragraphs, 21 and 22. And in paragraph 21, you were then tasked as co-chairperson to go ahead and meet with Advocate Ackerman and to essentially tell him the views expressed at the meeting, that Ackerman should not be involved in the TRC cases and that Picoli should remove him and consider appointing somebody else to handle the cases. Just for the record, Advocate Picoli confirms that in his evidence before this commission on the 13th of March. We don't have to go there. I'll just quote it quickly, but it's for the record. It's the transcript for the 13th of March 26, page 154, line 16. Picoli says, "It is correct that Advocate Simelane came to my office to have Anton Ackerman removed, and I told him in no uncertain terms that this is not going to happen. I'm not going to remove Anton Ackerman. Is that also your recollection?
Yeah, I didn't go to his office to have Ackerman removed. I went to his office to indicate that a meeting is requested with him and what it would discuss. And then, as a courtesy, I gave him a heads up that this is what would be discussed at the meeting because this is the view here.
Although that wasn't a matter of courtesy, I understand from paragraph 21, you say you were tasked by the meeting to go and speak to Picoli.
No, if you see, I was tasked as co-chair to go and indicate to Advocate Picoli what the concern was and that the view held by the police and the intelligence services is that it was not supported that Ackerman lead this process. So what I was saying there, that I was telling him that the meeting that is being requested with him, because the meeting that the cluster asked take place, is that it must be a meeting of those DGs in the cluster who felt that way, right? And therefore, it wasn't going to be my meeting with Advocate Picoli only. So me telling him that that meeting that has been requested with the DGs would discuss was a courtesy so that he's aware and is able to prepare accordingly, obviously, that when it comes to that meeting, he should expect that that type of thing would be raised with him. And then he would have prepared accordingly, however he would have prepared.
Yes. And if I can ask, you yourself, did you support the view of those in the meeting, SAPS and NEAR, that Ackerman should be removed from the TRC cases?
I didn't disagree with it. I didn't necessarily also support it. But I felt that if it was necessary for the program to move, then it needed to be discussed and it needed to be resolved. And that was going to take place in the cluster when the matter was basically tabled for discussion. And obviously it never got to that particular point because it was resolved.
So do you regard yourself as something of a messenger? You were simply passing on the views expressed at the cluster meeting?
Not in that sense, because we are partly, yes, a messenger, but not really a messenger because we are the co-chair of the cluster. So substantively, we are dealing with the issues and you are leading those types of discussions. So I wasn't a messenger in the sense that you're just passing a message, but I was required to engage substantively with the issues to assist the cluster find a solution to the problem.
And of course, as co-chairperson of the cluster, were you not somehow duty-bound to act in the cluster's interests?
Beg your pardon?
As co-chairperson of the cluster, were you not duty-bound to act in the interests of the cluster in terms of what it wanted to achieve?
Yes, absolutely. You have to. And remember that the interests of the cluster, I did indicate, if you recall, how the cluster, what the cluster composition looks like. And for that cluster, its only job is to have oversight and monitor programs. The separate issue of the DGs that from the police, intelligence services, defense, that had a specific problem wasn't a cluster issue, but it affected the cluster. So what the cluster was saying was, to the extent that our program is not moving forward because it is affected by lack of cooperation, firstly, individually, those departments must find a way of explaining what is the difficulty with cooperation. But to the extent that that now affects the cluster, then as co-chair, I was asked to say, please engage with colleagues, because if you recall, again, I indicated that those, within the cluster, there were then those core security departments that formed themselves, I think what it was referred to in the evidence as a forum. So those DGs, can the co-chair and those DGs meet and discuss this issue that is impacting on the cluster in this particular manner? And then co-chair, can you and those DGs also meet with the NDPP to discuss this particular matter and actually find out what the actual problem is, engage with the issue, and then come back and report to the cluster what the issue is. That's what I was mandated to do, yes.
Now, you mentioned in paragraph 21, you talk about Ackerman's history. Because of his history, there was unhappiness, especially on the part of the police and the intelligence services. What was that history that you passed on to Picoli?
I didn't pass on any history to him. What I indicated was exactly what the other DGs would indicate, that their members complain about his past involvement as a prosecutor. Basically, in prosecuting what they would refer to as comrades when they came into the country deployed on whatever mission. His role as a prosecutor in basically prosecuting those who would have been arrested at the time. But they didn't indicate the specificity of who they were, but it was in that context. At least that's how we all understood it.
Yes. And at that, and at that time and subsequently to this day, they've never put up a particular matter in which Ackerman prosecuted a comrade, perhaps in a problematic manner.
No, not that I'm aware of.
All right, then let's move on to paragraphs 23 and 24. And this then deals with the meeting in the west wing of the presidency. And you mentioned that this was not a regular cluster meeting, including all the departments. And you indicate that present were members mentioned in paragraph 19. And we've gone through those individuals. We won't repeat that. And you state that, I remember these ones because they were most vocal about the concerns of their departments. From their contributions in the preparatory meeting, they indicated their concerns to be informed in part by their and their members' personal experiences with the operatives of the apartheid government as commissars and commanders in exile, and also in part from a lot of comments and reports that they were receiving from their members in the department and outside of government. So in that discussion dealing with these personal experiences with operatives of the apartheid government and then the comments and the reports refer to, were any of them connected to Ackerman, and if so, could you elaborate?
No, not that I recall, not that it was mentioned. None of them specifically indicated how they interacted with Ackerman. The only account that they were giving was that is what they were receiving from their members. So pretty much anecdotal stuff. And our concern was that whether it was true or not, it was not something that concerned the cluster. The only issue was how is that affecting the cluster? And how it was affecting the cluster is that you are not able to send members in the manner that it was expected would happen because of the way they feel. So the issue was, is there a way in which that issue can be resolved? And what basically is required to resolve it? That's what I was then tasked as co-chair to go and assist, inquire into, and establish and report back on.
But you agree that if any of the members had personal experiences in relation to Ackerman, they would have raised them?
I don't know if they would have raised them, but they didn't, not that I recall.
Yes. So as matters stand in that meeting, although they raised personal experiences and referred to reports and the like, and none of them were connected to Ackerman. Now, in that context, what was the basis to move against Ackerman if there was absolutely nothing on him?
What was the basis to move against Ackerman?
Well, the basis to seek his removal when there was nothing to justify his removal.
Well, I'm not sure that one can only look at it in that particular way. What you do have, and I think we dealt with the issue of TRC matters and how they impacted on different people based on their experiences. If the issue here was that we're not able as, for example, National Commissioner or head of of Intelligence Services or Secretary of Defense, as head of department, I'm not able to forward names because those members I propose to forward or are discussed for forwarding are reluctant to go, or others were refusing to go. That is what the cluster had to attend to and assist those heads of departments address and attend to. So if their view was that in the past, somewhere in the history of the struggle, their experiences with the apartheid regime was that they had an experience that involved Mr. Ackerman. They didn't have to disclose it for us to properly assess and consider the issue. But if they felt it is their experience that made them uncomfortable to again physically and emotionally work with that individual, then the cluster has to consider those particular views and then make a decision based on that. So at this particular point, at least this was a meeting to explore how that particular issue can be resolved. And if indeed it was just the only issue or if there were others. But at least what was required at this particular point in time, at that point, was that at least have a meeting and talk about it and then come back to the cluster and give us feedback, and then we'll take it from there as the cluster.
So you mentioned that there wasn't a duty to disclose anything about Ackerman. But surely the opposite is true. If the cluster was seeking his removal, there was a duty to disclose what the members knew about Ackerman and why they felt that he was particularly problematic in that position.
No, the cluster never sought removal. I don't know if...
Sorry, removal from the TRC cases, not removal from the
Yeah,
PCA.
that's not the cluster position. It's never been the cluster position. That aspect never got to that stage where it was discussed. The people that sought the removal of Mr. Ackerman from TRC cases were the ones I've mentioned. The only issue that the cluster was not concerned about Mr. Ackerman or anybody for that matter. The cluster was only concerned about whether the program is running as expected. But when the cluster became aware that it is not running as expected, because there is still this lack of cooperation, then the cluster said, can this issue be looked into? And then those particular DGs, because they were the ones specifically affected and were contributing to the impasse, then needed to meet with the NDPP and engage on that issue. They are the ones who were seeking for Mr. Ackerman to not be lead in TRC matters. So it's not the cluster, that's the first thing. So whether or not they were to disclose would have been up to them if they wanted to disclose. You know, some of the issues would have been personal, as it were. But also, we never got to a discussion that please produce the information. We're still only at a stage where they indicated their views and that needed to be communicated as the reason, and then we needed to discuss it.
Now let's turn to paragraph 24. In here you indicate that the members raised concerns and dismay about the alleged change in attitude of Advocate Picoli. And then you state in the middle of that paragraph 24 that, and you give an example, I suppose, because like them, he shared the same views and as DG had penned a memo for the cluster motivating for the dissolution of the DSO. Now, Mr. Picoli disputes that he called for the dissolution of the DSO or penned any such memo. What's your response to his denial?
I can only note it because I don't know, but that's what those individuals had said.
Okay. Yeah. And this memo that he apparently or allegedly produced, is there a copy of that memo? Can it be produced?
No, they actually never produced the memo. They just spoke about the memo that he had written on their behalf. It's something they jointly had discussed at some point, yes. But they never actually produced it, so I never even saw it.
Okay, so it wasn't produced then, and as far as we know, it's never been produced.
Yes, absolutely, no, I've never seen it.
And also in the same paragraph, you mentioned that some of these members, what you call them personalities, they knew each other. And some indicated from the time they grew up together in the same area as Gebera. Now, Mr. Picoli also disputes that. He says that of the people there, he did not grow up with any of them in Gebera.
Yes, what I was saying there is that in the discussion around how to engage with the issues, almost all of them, in a way, were surprised at what they said was Advocate Picoli's change in attitude and tone. And they were saying they are surprised because prior to his appointment, while he was with them as DG of Justice, they'd all engaged with these issues and they'd all understood that they are in sync. In other words, they understand what needs to be done. So with his, what they felt was a changed, or what they thought was on his part a change in approach, they were then surprised and they were not sure why. And in one of the instances, they indicated that it is possible that maybe it's because he's isolated, because they had understood that part of him going to the NPA was to obviously capacitate it, and that he would be assisted with additional capacity from the outside so that he's able to deal with the environment. And that apparently either didn't happen or took long to happen. And therefore they felt that it's possible that he's isolated. But to deal with his change of tone or attitude, as the case may be, they were discussing that somebody either must be found, or those guys who at least who know him from Quebec. I can't remember the township in PE, but there's a popular township in PE where Advocate Picoli comes from. So there was a view that at least offline, a soft approach would be to find people or amongst themselves who would have grown up with him. At the time, I understood that maybe they were referring to Advocate, to Mr. MT, who was also from the Eastern Cape. But I don't know if they're referring to him, but that's what I thought. But the discussion was that let's rather find somebody who can talk to him offline and just find out what his concerns could be that has occasioned a change in tone. So that's the context of that particular. Yeah.
So that Advocate Picoli, he's made the denials that I've mentioned.
Fine, yeah.
You know, he denies any change in his approach. Do you have any reason to dispute Picoli's denials?
No, I don't know, because I don't know what they discussed. I wasn't there.
All right, then let's do a bit of a jump. Let's move to the next group of paragraphs, 27.
Mr. Vani, before you move
Yes,
away,
Commissioner. Yeah.
Mr. Similani, can one use, in this context, in paragraph 24, can one use isolated and surrounded in the same sentence? They seem to mean different things. You spoke particularly of isolated, but you have not said much about surrounded. Can you say something about that?
I think I put those in those inverted commas because I'm trying to indicate what almost one understood to being said. It was more like a crypted message on their part to say he's isolated. This is what they'd understood his deployment to the NPA would entail, which is him going and then support provided. And in that context, the way they were saying is isolated or surrounded, it's almost as if he could not be able to move on his own independently, and that because he's now in that environment, it was a possibility that he would have been pressured by that environment to be aligned with it, which those DGs would have felt was inconsistent with what they discussed and agreed with him much earlier before going there. So it was really a cryptic message that he's isolated because he's by himself, or surrounded because the environment around which he was now working had put him in a position where it was not easy for him to stick to what he had agreed with his colleagues prior to him moving there.
Yes, thank you.
Thank you, Commissioner. Let's move to paragraph 27. And you start in that sentence by saying, in the meeting, which only had one agenda item, the approach was informal. What was the agenda item, or the one agenda item?
No, it was to find out basically what the issue is between the NPA and the police primarily that was leading to the lack of cooperation.
Wasn't it obvious that the main issue was the presence of Ackerman?
The presence of Ackerman in the meeting?
Not in the meeting, but as the lead TRC cases prosecutor at the PCLU.
Yes, I understood that issue would be raised, that Ackerman would be the problem, but one wouldn't want that to be presumptuous. The issue was we needed to put it on the table that there's lack of cooperation that's been reported in the cluster, and what has also been reported to the cluster is that this lack of cooperation arises because of the following things, and specifically that Mr. Ackerman. So the idea for me as co-chair was to first have both sides present in the meeting confirming that, because we had not heard a view of the NPA that was the position. And remember, in the cluster meeting, I would have been, as head of Department of Justice, I would have been speaking on behalf of the NPA based on the reports that they would submit to me. They don't have an opportunity to speak for themselves. And an official that would have come with me to that cluster meeting from the NPA would have naturally confirmed that. So all that the cluster had really was a version which was one-sided. So the purpose of the meeting was to get the other side of the story, if indeed that is the problem as experienced by the NPA. So the starts and the introduction of the issue would be that there's lack of cooperation. This is what has been reported to the cluster by these departments. NDPP, can we have your perspective? Well, firstly, that there is lack of cooperation, and what in your view as the NPA is causing that?
In terms of the timing of this meeting, you mentioned that it was likely 2006. Do you have a sense whether it was early 2006, maybe mid or towards the end of the year?
No, that would be very, very difficult for me to say precisely, no.
Okay.
Could have been any time then.
Now, typically these cluster meetings, I imagine they would have been recorded and minuted.
Yeah, the formal cluster meetings are always formatted. There's a formal agenda. They're like board meetings. They're also, their program is spread out throughout the year. They are formally scheduled meetings. Those are compulsory. They can't be missed.
But as far as you're aware, you or the Commission have not been able to get hold of a minute or record of this particular meeting?
No, I didn't ask. Personally, I didn't ask for those minutes, I didn't feel that I needed them.
Right. So it might be available, but you haven't asked for them?
No, I personally haven't. Yeah, they should be available because those are formal documents, so they get archived in terms of appropriate legislation.
Okay.
So whether they can locate them as quickly, I don't know, but they should be there.
Well, it does sound like it's quite a key meeting, so we will ask the evidence leaders to make efforts to locate those minutes.
Sorry, not this meeting, by the way.
Not this meeting?
No, this meeting, remember, this was not a cluster meeting.
Okay.
This was a meeting of the certain DGs of the cluster who were asked to meet informally with the NDPP and find out what the problem is, and then come back to the cluster and formally report to the cluster. It is that meeting that would be.
Oh, I see.
Yes, no, that,
So-
that
so-
meeting was not minuted. The one in the West Wing, no, that one was not minuted. It was really an informal meeting.
Okay, but you know, normally though, wouldn't, you know, meetings, whether informal or formal, with senior government officials, would it not be minuted in some form, or a record kept of any nature?
No, not this one. No, not this one. It's not a formal meeting. It's a meeting outside, basically, if I want to call it that. It was not a formal meeting. The formal cluster meetings involving all the DGs of the cluster, those ones are minuted. Those ones are formal.
Okay. Now, you state at paragraph 28 that Advocate Picoli was accompanied by Advocate Ackerman SC. And you also recall at some point that Mtunzi Maga, Advocate Sean Abrams, and Advocate McAdams in the meeting, or possibly a later one. Now, Picoli states he disputes that he ever attended such a meeting with Ackerman. What's your response to Picoli's denial?
I stand by my statement. Ackerman was in the meeting. What I just couldn't remember, which is why I put it like that, is whether Mr. Maga and Mr. Abrams and McAdams were in that meeting themselves specifically. But all I can say is that Advocate Picoli didn't come alone to that meeting. I just don't remember whether the others were there, but Mr. Ackerman was in that meeting.
Chairperson, it's almost 11 a.m. Would this be an appropriate time for the
Yes.
tea adjournment?
We'll adjourn for tea and reconvene at 11:15.
As the Commission pleases.
Thank you, Mr. Vani.
As the chairperson pleases. Advocate Similani, before tea time we were, just to remind ourselves where we were dealing with the meeting in the West Wing.
Yes.
And we were referring to various aspects arising from paragraphs 27 through to 29. And then just to wrap up those particular paragraphs, I just want to put to you what Ackerman SC testified in relation to his presence at this West Wing meeting. Commissioners, this is from his transcript on the 5th of March 2026, at page 48, line 20. So Advocate Ackerman says he did not attend the West Wing meeting, and he even goes so far as to say that he's never been in the West Wing. What's your response to his denial?
I don't agree because he was at that meeting.
Okay, then if we can turn to paragraph 29, you indicate that the meeting then informed Advocate Picoli of the discussions of the cluster. And then they then confirmed the message that I had communicated to Advocate Picoli in our meeting. And then in paragraph 30, it's indicated that Advocate Picoli stuck to his position exactly as he had stated in your meeting, and he indicated that since Ackerman was head of the PCLU, he was responsible for the TRC cases and he would not remove him. In paragraph 31, you then say that the mood of the meeting changed and there was tension. Was that because Picoli had stated that, perhaps in no uncertain terms, that he would not remove Ackerman from the TRC cases?
Yes, I would say so. I mean, there was tension before the meeting. I think everybody was uneasy because of, obviously, the way things had panned out up to until that meeting. But yes, when he expressed himself and he indicated, yes, one could feel that, okay, there's tension now as a result of his response.
So then you also indicate that, and this is in paragraphs 32 through to 34 and 35, that Ackerman allegedly spoke about the PCLU investigations, and in particular from paragraph 34, he described various cases against individuals in the ANC, and that some of these cases were ready for prosecution. And that at this point there was consternation. You mentioned that the meeting descended into some disorder. And this was because, as you say in paragraph 35, no one in the cluster was aware of those investigations. And here I think we can assume that those investigations were the ones against the ANC. Yes. So the question is, there appeared to be an expectation in the cluster that they be kept informed of specific investigations like the ones allegedly against the ANC, but they were not. Am I correct in saying that the cluster had that expectation, that they would be kept apprised of such investigations?
No, you would not be correct. I think my recollection, what surprised everyone, me included, was that there was an issue that was introduced that seems to be not consistent with what we understood TRC cases to be about. We understood TRC cases to be those that didn't get amnesty. But when Mr. Ackerman briefly explained what they were doing, it was for the first time, well, at least that I had heard, that there was that kind of work being undertaken by the NPA. So it was that surprise, basically along the lines that where's this issue coming from? Because it's not the one that we had understood it to be. That basically was that. Not that there was an expectation that there would be, the cluster would need to know about every investigation, as it were, whether that one or even the other ones. The only expectation of the cluster was that progress on the TRC cases would come in the normal course of reports that get submitted to the cluster by the department.
But is it not true that, if you say that when we speak about the TRC cases, it's essentially those cases in which amnesty was not applied for or not granted?
Yes.
But am I correct in saying that that cuts all ways? It doesn't matter which political faction had been denied amnesty?
Yes, it should cut all ways.
So then where would the departure be in relation to those particular investigations, assuming that that's what he said?
Well, I think at the time, the issue with these ones is that, when he presented, he indicated that, what the people that spoken to were coming to them about were reporting what had taken place for example, in the camps. So it's not something that the cluster had discussed at any point in time and had been receiving reports on. So this was, for the first time, kind of account. And for that to have been brought in that meeting is what was a surprise. Maybe if it had come via the normal reports, it would have been a different story. But there had not been, prior to that announcement, there had been no prior reporting to the cluster about those kinds of cases.
But why should the cluster be surprised, given that the TRC did look into violations that took place in the camps, and so that was on the agenda of the TRC?
I suppose because it hadn't been reported before. If, for example, it was something that had been reported, like all the other cases that came that were reported in the progress reports, it would have been a normal thing. This one just came out of the blue, and we had not been briefed about it at any stage whatsoever.
Yes. So in fact, there was an expectation that if the PCLU was busy with such cases, that they should have reported that to the cluster at some point.
As part of the normal program, yes. Not necessarily on a case by case, that this case, this is where it's at. It will be a report of how many cases, maybe which locations, what briefly they would be about, but not the details of each case.
Now, you mentioned that once these investigations had allegedly come to light, that the meeting descended into some disorder. Can you describe what kind of disorder that was?
Well, in the sense that basically everybody started speaking at the same time. People were no longer focused on the order that the meeting had been following, where the chair was allowed to, recognize people to speak. Everybody started speaking and they started talking to each other, basically not paying attention. So it became a bit chaotic and it disturbed the flow of the meeting. That's what I mean.
So Picoli states that, he hasn't attended any cluster meeting that descended into disorder. What's your response?
In this meeting, he definitely was present, because that meeting took place with him.
All right, let's then turn to paragraph 36. And you state in the first sentence, the argument being made, as I can recall, was that Ackerman was referring to was not part of the known POA approved by Cabinet on post-TRC matters, and that if the PCLU was conducting those investigations, why is that issue being included in the one that was an approved program of the cluster? So essentially, you're saying that those kinds of investigations were not part of the POA approved by Cabinet on post-TRC matters. Firstly, for the uninitiated, what is a POA?
It's a program of action.
Okay. And more specifically, what is a Cabinet POA?
No, it's basically the annual program of each of the clusters. Every year after Cabinet Lekgotla, all of the clusters would have the programs that they'll be running through their departments, and they are all consolidated in what is called as a program of action for that calendar year.
Yes. And so there was one on TRC matters. Do you have a sense or recollection as to approximately when that POA was decided upon or issued?
Well, every year there's a POA for every year. So post-TRC matters would have been in each POA in each year.
And as far as you're aware, those particular kinds of investigations were never in the Cabinet POA on the TRC matters?
That's how it was understood. That's how I understood it. That if there were cases of the type that he was describing against a particular person in the camps, that was not understood to be necessarily within the same TRC matters that everybody understood in the POA.
And do you know who was involved in drafting that particular POA?
No, not specifically individually.
But would it not have been individuals in the DG cluster or individuals that the DG cluster would have delegated such tasks?
No, if I recall correctly, it would come from the presidency. Because every department contributes input in terms of programs that each department would propose to be conducted in that particular year, and then after discussions in the Lekgotla, then they are prioritized. And after they are prioritized, then they are communicated to each of the departments.
So the president does the
drafting,
drafting, but they're dependent on inputs from the departments.
Yes, general departments do make inputs, yes.
Am I right in saying that once drafted, it's then tabled at a cabinet meeting for approval?
It's usually approved after the Lekgotla, it's usually approved because it's agreed. I'm not sure if it actually goes back to cabinet again, but it will be formally communicated to each of the clusters as a cluster program, yes.
Although if it's called a cabinet POA, then presumably it has to be approved at some point by cabinet.
Yeah, it may very well, but I just don't recall specifically if it goes there in that way.
And that once it is approved by cabinet, it then becomes effectively a cabinet decision or directive.
Yes, yes.
And am I right in saying that once it is approved, that it's then at least politically and administratively binding on departments?
Yes, department must implement what is within their core mandates.
Yes.
Yes.
Would it also be binding on the NPA?
Yes, it would, because the NPA is part of the department.
Did you ever get to see the POA on the TRC matters?
Yes, we'd see it, yes. Every DG would definitely see it.
And you can confirm that the cases that Ackerman was talking about was not part of that POA.
I don't recall the specifics. The POA wouldn't have case-specific matters. It would have just subject. So to talk about TRC matters, that's the kind of program it would be. Then the department would then break that down in accordance to sub-themes within that major theme.
Yes.
That's how it would work.
Although you're quite definitive in your statement that the cases that Ackerman was describing were not part of the approved POA.
Yes, because it wasn't understood that those kinds of cases would fall within the broader TRC cases.
Now, can I ask why should Cabinet, through a POA or any other device, why should they be deciding what matters like TRC cases be investigated and prosecuted?
I'm not aware the Cabinet would discuss cases or TRC cases, but it would discuss the post-TRC. If you remember, I did indicate that when the TRC finished its work, the report was obviously submitted to the President, and it would have been discussed in Cabinet, and then it would have been agreed that it must be implemented. So the program of action would follow progress on that particular report. That's
Yes.
how it would be, yes.
Yes,
It
but
shouldn't be a discussion of a specific case.
No, we're not talking about specific cases, but we're talking about types or categories of cases. And this is where the families will be asserting that the political meddling in these cases, they will say, it did start at the very top with these kinds of directives through this POA being issued by Cabinet.
No, that'll be definitely incorrect, because that's not what Cabinet would decide. At least as far as I know how Cabinet works.
Yes, well, it is an argument that we will be making on behalf of the families. Let's turn to paragraph 37. And here you point out that Ackerman sought to provide additional clarity, that they couldn't ignore complaints, and that the approach would be, that start on one side and then move to the other side. And then the example of a list of members from the Political Military Council, the highest decision-making structure of the ANC in Lusaka, was subject to the PCLU investigations. I suppose my first question is, was it any business of the DG cluster to look at prosecutorial strategy of the NPA or PCLU?
No, it never did, and it never asked for a strategy. But it would have commented on it based on what would come out in the reports.
Yes.
Yes.
Well, when we talk about strategy, I suppose we're really talking about case selection. And case selection, I think, is at the heart of the dispute or the disorder that arose in this meeting. Would that not be correct?
You can call it that, but it was more about whether what Mr. Ackerman was describing was something that fell within what they ought to have been doing, or at least within what we understood was their task they were supposed to do. So the manner in which he presented it, as I said, it's information that had never been reported in any of the progress reports. So I think that's what created the problem, hence the questions too.
So, Mr. Picoli said that the claim that Ackerman said that, he will prosecute one member of the liberation movement and then proceed to prosecute one from the apartheid security sector, He denies that that was said at the meeting by Ackerman or anyone else. In fact, he says that this was the allegation that the late SABC Commissioner Celebby used to make against the PCLU.
I don't know what Mr. Celebby used to say about the PCLU because I wasn't there, but at this meeting that I'm referring to, he definitely said that.
Okay. Now, you also mention in paragraph 37, well, you made reference to the fact that the NPA had a list of the members of this political military council. I think the correct term is political and military committee based in Lusaka. And in fact, in the same paragraph, but on the next page, you say that the list, the list was produced and alleged to be of the members of the political military council, and it was passed around for everyone to see. Who produced that list?
Mr. Ackerman produced it, if I remember correctly.
So that's, I suppose that was an explosive list in a sense because it included the highest ranking ANC members on the council in Lusaka. Did you ever retain a copy of that list?
No, personally, I didn't get a copy. I'm not aware if a copy was made, but it was passed around for people to have a look at it.
Yes. But it must have become immediately quite a well-known list. It's odd that we don't have a copy of that particular list anywhere. Or let me put it this way, don't you agree that it's strange and odd that such an explosive list and there's no copy to be found?
Well, that's strange because it was there, it was produced, so somebody must have had it and filed it somewhere. So yes, it is strange that it can't be produced all of a sudden.
So we have a bit of a problem with the timing about the concern raised about the NPA possibly acting against the most senior ANC leadership. Because after all, we're dealing with a meeting that took place sometime in 2006. And I want to put to you a media statement that was released by the NPA. In fact, it was the NDPP, Bulelani and Guka, and it's at page 723 of the cross-examination bundle. Supplementary bundle. Sorry, it's not page 723. That's from the bundle it came from, but it's the first page in the NPA supplementary bundle. Oh, my apologies. It is actually page 723 of the cross-examination bundle. Do you have a copy in front of you?
Is it this 723? This one in yellow. Okay. Yes, I've got it.
Okay. It's titled NPA Release, Media Release. It's dated 15 May 2004. And the title is NPA Closes the File on 37 ANC Leaders. I'm not going to read the whole thing into the record. It's already before the Commission. First paragraph simply says the NPA has decided not to launch any investigation into 37 ANC leaders who were refused amnesty by the TRC. and it was issued under the instruction of then NDPP Bulelani and Guka. And it sets out the detail why the NPA is not going to be prosecuting the ANC leadership. Now that received some publicity back in 2004. So I must put it to you that that you and your colleagues on the cluster must have been aware that the decision had already been taken in previous years not to prosecute the ANC leadership. And yet here your account of this meeting in 2006 deals with attempts to go after the ANC, which simply cannot be correct.
Well, I didn't know about this particular media release and this issue as reflected in this media release being discussed because I wasn't there. And when I joined the cluster, it also not an issue that was raised with me or that ever came up, such that I could have known about it. I only got to know about this in these proceedings. But the issue here is that it was Mr. Ackerman that introduced the issue of a list in a meeting that was there to discuss something completely different. And all I was describing in my statement was a reaction of those present in that meeting to the production of that list. As to why he did it, I don't know. But he had been asked to comment, to brief those present about the work of the PCLU, which is what he did. Why he then went further to produce the list and express himself in the manner that he did, I have no idea.
Because, aside from the public media release, the evidence of Mr. Ackerman and Advocate Picoli before this commission is that there were no developments from the decision taken in 2004 not to prosecute the ANC leadership. And they repeated themselves on numerous occasions that had not changed. So in the light of that, we must put it to you that casts serious doubt on the veracity of your account of this particular meeting.
Now, what I put in the statement is, firstly, the existence of the meeting, and secondly, what happened in the meeting. That's correct.
Yes.
That's exactly, it happened exactly as I've described.
Well, you'll understand that in our arguments to this commission, we will be arguing that this account cannot be accepted in the light of the known facts in relation to the decision to prosecute the ANC leadership. I'm just putting that to you so that you're aware. You can respond if you want to.
No, it's fine. I understand what you'd be arguing, yes.
Let's move to paragraph 39.
Just go back again.
Sorry, this is not back in your main statement.
Yes.
Now, you allege there that, and I think the second last sentence, that Advocate Picoli then indicated that if the members insisted on the removal of Ackerman from the TRC cases, then he will remove him, but that he will seek his counsel anytime if he needed it. Now, Advocate Picoli disputes that he ever said that he will remove him, but then just seek his counsel. He denies that. What's your response to his denial?
No, I hear that, but that's exactly what he said at the meeting.
And let's turn to paragraph 40. You state that it became no longer conducive to continue with the meeting because the focus had become this list. You then point to the agreement that had been reached, the agreement that is in dispute. And you then say that the NPA and the police, as responsible parties for these matters would then continue with their mandates and take the processes forward accordingly in the normal course to the cluster. Now, I want to put it to you that is difficult to accept. You know, we just heard that this explosive list of the most senior ANC members had been put up, which the NPA were apparently proceeding with. And yet you state that that the purpose of the engagements had been achieved, and that the NPA could simply continue in the normal course. Surely it couldn't have been left just to let them carry on as before?
Okay, I'm not sure what you mean, but what I'm saying there is that the purpose for which the meeting was set up was achieved because there was an outcome from that meeting, which was an agreement by Mr. Picoli that you would then remove Mr. Ackerman from the TRC cases, except that you would use him whenever you needed him. So the purpose of that meeting basically was achieved, and there was no longer a need to discuss the issues further. What I mean there by saying the matters between the two departments, not the two departments, between the NPA and the police would then go on as normal is that based on what had been reported to the cluster, which occasioned the meeting, that there's lack of cooperation because of Mr. Ackerman. Now that it was agreed by Mr. Picoli that you would then remove him, then what was the cause of the disagreement would have fallen away. Therefore, cooperation would be expected going forward. That's what I mean by that, when I say in the normal course.
Okay, I suppose my surprise was that, you know, one had a list of cases that did not form part of the cabinet-approved POA, so I just found it difficult to believe that the NPA could be left to carry on in the normal course. But you've answered that. Let's move on to paragraph. Hold on. Let's stay with paragraph 41, because I think you do then indicate what was going to be happening in relation to those cases, and you say in 41 about the fifth line. You say investigations were being conducted on a program that was not considered as part of the approved POA and approved by Cabinet. Further, that these activities been linked to the post-TRC matters is not appropriate, since they were not the same and were not previously discussed as part of the TRC matters. Their inclusion, therefore, would be inappropriate unless specifically approved. In addition to that, the President and some members of Cabinet were under investigation, possibly without their knowledge, and that the investigations that Ackerman referred to may result in prosecutions. Then at a minimum, the members of the cluster needed to report these developments. So firstly, if senior individuals, you know, like cabinet members, are being investigated, do they need to be told about investigations in which they are suspects?
Well, they don't have to be told by the person investigating them, but anybody else who's aware of it can tell them. There's no bar to that.
It's just that the concern being expressed here is that senior members of government are being investigated without their knowledge. So there does seem to be an expectation that that it should come within their knowledge. They should be told.
Yeah, not that there's anything wrong with letting them know, but in this particular context, we felt that it is important that they are aware that firstly there are these kinds of matters, because we needed to discuss them to be certain for ourselves that indeed there are matters that fall within the TRC matters as we knew them and as they were being reported. And because these ones were not being reported, so we therefore needed to be certain that what we're informed by Mr. Ackerman is appropriate work that the cluster should be concerned with. And that then obviously in the normal course of the departments in the cluster and the cluster's work, that needed to be reported formally so that it is known.
So
At what point should these senior members be informed that they're being investigated?
At what point?
Yes, at what point should they be informed? Was it discussed? At what point?
Well, for purposes of the cluster, it doesn't matter at what point. It's simply to report that there are investigations underway, and this is the context in which those investigations arise. It's part of the program if it's part of the program, or it's not part of the program if it's not part of the program, and you leave it at that. The focus is not to inform an individual what an investigation into them looks like, because the cluster wouldn't have that information, it wouldn't know. So all that was being reported here is that there was a meeting. What would have been reported is that there's a meeting of this nature that took place. This was the context of that particular meeting, and this is what came out of that meeting, so that everybody knows. So this is just an account of how the DGs after that meeting sort of debriefed about.
Yes, thank you.
thank you, Commissioner.
Can I ask a question?
Yes.
What would the purpose be of such a report?
The purpose is to inform in the normal course. The cluster reports on everything. So in other words, if any work is done operationally that relates to the work of the cluster, a report must be produced to demonstrate that the cluster is doing its work.
So I understand you to say that the NPA had to report on operational matters.
No, it's not the NPA reporting. The NPA does its work however it does its work. But this cluster would need to report as part of progress of TRC matters.
On the operational matters of the NPA.
On the progress of the TRC matters. So it would be operational matters in the sense that we would say the NPA has provided, I would say as the DG of Justice, here's the Department of Justice report. In respect of TRC matters, here's the report from the NPA, and this is what it says. However, the NPA would have reported it, so that everybody knows that at least the program is going forward. So what the cluster would be interested in is, are the cases currently running in court being prosecuted? How many and in which locations? And naturally, if they were, they would be public, so they would indicate maybe it's state versus whoever it is. Others, they're not in court, but they are at an advanced stage, and they're likely to enter the court roll in 6 months' time. It would be that kind of reporting. But what the cluster gets a picture of is that there's movement. What had happened before is that there's no movement because there's no cooperation, hence this meeting.
Thank you.
Thank you, Commissioner. Then, in respect of the reporting, let's move to paragraph 42, because you do say the first reporting was to the ministers of the cluster. Can you recall approximately when this, and I'm assuming that it was a meeting or a briefing, as you state in that paragraph. When was that approximately, or how long after that West Wing meeting did this take place?
I can't remember exactly, but it was not too long. I think it was maybe at the most it should have been about a month.
Okay. Am I right in saying that as one of the DGs you would have been present at that?
I was
briefing?
present in that meeting.
Yeah. And you do give an account in paragraph 42 what the concerns were that these kinds of investigations fell outside of the POA, and you say in particular, because these matters were not included, that they would require a separate discussion and decision by Cabinet. Now, why would cases like this, we're talking serious crimes, mostly murder, kidnapping and the like, why would there be a need for Cabinet to revisit this and have a discussion and take a fresh decision?
There won't be a revisit I mean, the investigation as far as police and the NPA would continue in the normal course. I mean, nobody tells them what to investigate and what not to investigate. But as a formal addition to a program that's already approved, is that anything additional would need to be reported, that this is what we'd wish to add so that it is supported or agreed, naturally to be motivated. If it's an addition, that would be described as complementary and therefore necessary. It's that kind of reporting that would be known, because there are consequences to the program. There'd be a budget and those kind of things.
Yes, but that doesn't quite align with what you say in paragraph 42. Second line, the ministers inquired about these investigations by the NPA and whether the, and I highlight here, the decisions taken on the post-TRC matters included them. The DG's responded saying that the new matters were not included, and that would require a separate discussion and decision by Cabinet. So we're talking here that a decision by Cabinet was needed.
Yes, in the sense that if these were matters that were not falling parts of the TRC matters that were approved originally, and there were matters that were being introduced as part of the TRC, so they needed to follow the same, in a way, line of approval in terms of reporting to Cabinet that these are the matters, they fall within those. We would have needed to explain, for example, to say why were they not there initially, if they were not there initially, and there would be an explanation to that, and therefore approval for them to be included would be required.
Yes, and again, that is our problem with that approach, because here you have Cabinet effectively taking decisions in relation to the category of cases to be investigated and prosecuted. Surely that's no business of Cabinet.
I'm not sure it's about the category of cases. What would have needed to be approved is that these are cases that are parts of the overall TRC cases. To the extent that a view is that they were not initially included when they should have been included, therefore what would be required is that there be confirmation and approval that they be included in the normal course, so that there's no work that is done outside of Cabinet approval. It generally doesn't work like that.
Why would you need Cabinet approval to investigate serious crimes such as murder, kidnapping, torture, and the like? Surely that's not needed?
Of course it's not needed, but what would be needed here, and that's why I'm explaining the context, that in the same way that Cabinet approved the program in the first place when the TRC closed and the report was submitted, and if there were matters there that were not mentioned, that should have been mentioned in that report, now that information about them was known and made known in the way that it was, the view of the DGs was that that information must now be reported as well to the cluster, so that when it goes to Cabinet, then those matters are presented there so that they are known firstly that they are there, and if there's a reason to explain why they were not there initially, whatever the case may be, that would be done, and therefore that they continue to be investigated like all the others. So in other words, incorporate them into the program that's already running so that they go ahead. That's all that was proposed there.
Yes. Well, I must put it to you, Advocate Similani, that on behalf of the families, we will argue that this is evidence of political meddling in prosecutions of serious crimes from the highest level, including the Cabinet. All right, let's move on. Let's turn to paragraph 43. And in paragraph 43, well, the question of Ackerman's position was also discussed. That's in paragraph 42, but let's move on to save time. The other issue that the ministers inquired about was whether there was a framework in terms of which all post-TRC prosecutions were being dealt with. And the DGs indicated there was no separate framework, and that the prosecution policy of the NPA was the one that was being utilized. I assume that's the normal prosecution policy. And then, because of the nature of the post-TRC matters, the Minister suggested that the Minister of Justice engage with the NDPP about having a framework that focuses solely on the post-TRC matters because they were unique, sensitive, and important. Why did the ministers feel that there needed to be a separate policy or legal framework for these serious crimes as opposed to other crimes?
I don't want to speak on their behalf, but my sense of the issues is that the post-TRC matters were always viewed different to every other normal criminal matter, in that normal criminal matters really didn't entertain anybody unless there's a specific issue that arises from that particular matter or those types of matters. But these ones were specific because they were part of the broader program of reconciliation amongst others. And I suppose because TRC matters were highly political, having regard to their origins, as it were, and where the country was going as far as the future is concerned. So particular attention was paid all the time to what was happening in those kinds of matters. So dealing with them and the manner of dealing with them was always a sensitive issue for the victims, society in general, and also in relation to those who would be subject to investigation and prosecution.
But by 2006, by now the TRC had been wound up for several years. The amnesty process had been wound up also for some years. Surely the crimes in question, and again, I don't want to harp on the matter, but murder, kidnapping, torture and the like, surely they should have just been treated as normal serious crimes at that point in time.
No, I don't agree that they're normal. There's nothing normal about TRC matters. They're not normal like any other murder or kidnapping. There's a context to them, and rightly or wrongly, or whether one agrees or disagrees with those involved, there's a manner in which matters of that type needed to be approached because of the impact that they would also have on society in general. So they would need some kind of attention to make sure that they're done properly.
But don't courts always take context into account?
Oh, sure, that's for the other branch of government to do that. There's nothing wrong with that. But doesn't mean that any other branch shouldn't equally have the same kind of interest.
But you're talking about now the prosecutorial decision-making process.
No, I'm not talking about prosecutorial decision-making process. It's the impact of any investigation, whether or not it results into a prosecution, that is of interest. If it does result into a prosecution, it is also of interest for that particular purpose. Because overall, TRC matters are different because of the impact they have on the other work of the cluster.
So why I say prosecutorial discretion or decision-making whether to prosecute or not is because in your paragraph 43 you talk about the inquiry about a legal framework and that the DGs point out that currently it's the prosecution policy that is in place, and that prosecution policy deals primarily with the discretion of prosecutors to prosecute or not.
Yes, it talks about that, but it also talks about the manner in which they do that work, which is a policy issue and not necessarily a decision to prosecute or a decision to not prosecute. So how the work is done is not necessarily reserved for any one group. The rest of society is required, or at least is entitled to comment thereto. So what I understood, at least by that, at least in my view, I don't know about others, is that when dealing with these matters, for the reasons that I've described, there would have needed to be a certain sensitivity that enables everybody to at least be satisfied that there wouldn't be societal repercussions of a negative nature because of either the manner in which matters were handled or whatever outcome of decisions.
Now, we have a big problem with timing, again, in relation to your evidence, because here we're talking about deliberations that are taking place in or around 2006. Now, the efforts to come up with new guidelines or excuse me. So the efforts to come up with new guidelines, that started as early as February 2004, and granted that was before you became DG in 2005. But there is evidence before this commission that the DG's forum created an amnesty task team, and they proposed new guidelines which became amendments to the prosecution policy. And these were in fact promulgated in December of 2005. So it does seem that those guidelines or the prosecution policy amendments were already in place when the ministers raised whether there was a special framework in place, and they were told, well, there's just the prosecution policy, and then they called for a special legal framework for these cases. But that was already in place from December of 2005.
Yeah, maybe I could be, that would have escaped me or those who were in the meeting, but that would have been the context in which that point would have been raised, to say how that was the case. And I'm sure if maybe there was an opportunity to remind them, those that were present, that indeed this was the position, they would have either taken care of it, or there would have been an engagement further about whether it adequately deals with it. With the issues. So in other words, there would have been a want to assess whether it is assisting the processes or not. And if yes, obviously it's not an issue, but if not, in what respect, and how to further make improvements.
Well, I must put it to you that it's difficult to accept that the implementation or the promulgation in December of 2005 could easily have escaped your attention as DG of Justice and others in that cluster, and it does cast some doubt over the veracity of this evidence.
That is where institutional knowledge or memory comes in, Mr. Similane, because someone must have been present, who was present when those things were formulated and promulgated. So that's the point that I would also want to understand. No one with institutional memory to say, no, but look, you're reinventing the wheel. The wheel is existing.
No, certainly. No, thank you, Chair. No, certainly that's the point. If somebody remembered, that would have been the right time to do it. So I just recall the meeting in this particular way. But I understand the point. Yes.
Mr. Varney, before you move on, Advocate Similane, remind me again, you were the DG of Justice between 2005 to 2009.
Yes.
Right. So we know that the amendments to the prosecution policy were promulgated around December 2009. So they would have been in effect while you were the DG.
Apologies, Chair. I think that timing is wrong.
Timing.
The dates that you've mentioned now, you said 2009.
2005 to
2005.
2009. Have I got that right or wrong?
No, I thought, Chair, you said 2005 to 2009, I was the DG, and I said yes.
Yes.
From 1st of June 2005 to end of 2009, I was the DG, yes.
You were the DG?
Yes.
Okay.
About promulgation.
Oh, no, the amendments to the prosecution policy, I think they came into effect in December 2005 or early 2006.
If I recall from the evidence, it was December 2005.
And five,
yes.
right. Now, earlier you told us that these TRC matters were, quotes, highly political. Explain what you mean by that to me.
Well, the best way to, I suppose, to attempt to do it would be to say, why would you have a TRC? It's a Truth and Reconciliation Commission. Why would you need that as a country? I mean, what would occasion a need for such a thing to exist in the first place? So you'd have to then go back, and these ones, it's pretty clear that TRC matters relate to the past of the country, which we don't have to deal with. We know what it is. And that even post the democratic dispensation, there were many other groupings within the country, known and unknown, that continued their activities for their ideological reasons, even before, in other words, the activities that they did before 1994, the democratic dispensation, they continued thereafter, except that this time around, because it's a democracy, they would engage in those activities underground. Those would have been intelligence reports. And there was always continued monitoring of those groupings, whoever they were, on all sides, not just on the side of the liberation movements, because it was also accepted that the democratic dispensation, although we had it, not everyone was necessarily either in agreement with it or happy with the manner in which it was achieved, just as much as not everybody was happy with the manner in which the TRC matters were dealt with to this day. So in a sense, those remain political and will always be political for the rest of our natural existence because of that particular factor. So the cluster, as part of its work on a government program, had to sell the idea of a better future, even to people who didn't want to hear the message. In other words, if you are in government, myself, for example, as a bureaucrat and HOD, I implement a program I don't like because that's why I'm there. If you don't like it, you leave. But if you are there, you do your job and sell it as best as you can, even if you don't like it. In the same way that you implement a decision that's taken by a majority, whether you like it or not. You implement it as if you were advocating for it, when in fact you were not. So these remained political in that sense. What was always complex about them and remains complex today and may be not necessarily a subject of this particular commission is that there was a problem of askaris. In the sense that askaris were double agents. That's what it basically means. In that, I think I say it in the statement, that with the amalgamation of various homeland governments into what I call Pretoria government, everybody found themselves having to work with people they were not really sure about.
So,
in that sense. So that's the political nature inherent in any matter TRC.
so would that explain then the political interest in the prosecution of these matters?
Yes, the interest is not just so much that there's a prosecution. Who is prosecuted becomes important for other reasons, in that what constituency does that person carry with them? So if it was a general, for example, who held certain strong views about the democratic dispensation, the security interest would be about how those aligned with that individual would likely respond to such a decision. And if there is going to be a prosecution, what it would require is that alongside it, there are plans to manage any fallout that may happen in society. That's the idea always with TRC matters, just so that it's known.
Thank you.
Yes, ma'am.
Thank you, Commissioner. Advocate Simelane, let's move on to paragraph 44. Here you state the ministers were advised that the nature of the possible security risks inherent in the matter necessitated that they reconsider, or rather that they consider reporting to the National Security Council, the NSC. And they indicated they would consider that. What were the security risks inherent in these matters that that warranted possible reporting by the ministers to the National Security Council?
Well, it's basically what I've just described for the chair now, for the commissioner now, that if indeed there were going to be prosecutions across the board, in the normal course, there would always be a threat assessment that gets done by the intelligence services, both from crime intelligence to state security and defense intelligence. In the normal course, it gets done anyway. But over and above that, there would be a risk that would be done consequent to a particular activity that's taking place in terms of assessing what impact it would have, so that the necessary logistics are activated to mitigate whatever outcome the risk assessment would give. So that's, and again, because of the level at which this involved, which is political leaders across all political parties, as it were, it's at a national level. So a body like the National Security Council would need to be generally apprised of what is happening and what the thinking is and where things are likely to go for its own processes in terms of what it would then require for itself in terms of managing society and social cohesion. And that may include indicating to government that there must be political engagements, again, with a view to designing programs that would assist society to be reminded of a future going forward than the past. Because issues are emotional, it's psychological. It's psychological warfare. You play with society to keep it reminded of the bigger cause. So any prosecution of any one or two people, either way it goes, would require that kind of intervention in order to appeal to those who would have sympathy for those being prosecuted, that there is a bigger picture that we've all signed off on, and therefore everybody should allow the system to work and trust the courts basically to do their job and make determinations. That would have been the idea of reporting, and that's basically how things get assessed. It's not about the specifics of each one. These ones, because they're terrorist matters, they may involve even that particular element to say, well, it's X person, it's that person, and therefore these stakeholders need to be engaged. If it's the church, the Dutch Reformed Church, or whatever the case may be, those get activated. So the issue is much broader. It's not just qua security, it's also on the social side. I don't know if I'm assisted. Sorry for being too winded.
Thank you. So I want to put to you the testimony of Advocate Picoli, because he also testified on the question of risk and threat arising out of TRC prosecutions. And Commissioners, I'm going to be quoting from the transcript of Picoli's evidence on the 13th of March 2026 at page 442. And Mr. Picoli spoke about the threats and risks in the context of the intention of the NPA to prosecute former police officers and senior officials in the Chikani matter, sure you're familiar with that matter. And it was, the question put to Mr. Picoli was that the reason that those ministers were so concerned about the Chakani matter going ahead, and needless to say other TRC matters, was that a prosecution like that would give rise to calls for prosecutions of ANC cadres themselves. And Picoli answers as follows, and I quote, "Yes, taking everything in context, the context being key in trying to have an understanding of issues, whether simple or complex, yes. Given the fact that the then National Commissioner kept on saying that there is the sinister motive at the NPA, which started during the term or tenure of my predecessor, was that the insistence on the NPA to go ahead with these prosecutions is because they also wanted to prosecute President Mbeki and other ANC leaders, whether in government or outside of government. So this is what always has been dangled as some kind of a threat or risk which might actualize or realize once there is just a prosecution, particularly against former police officers." So Picoli is saying that the real risk or threat was that Ackerman and the PCLU going ahead against former police officers would give rise to calls to prosecute also ANC cadres. What's your response to his version?
Well, I can comment from what I saw in these proceedings. I have no objection to his assessment of the information in front of him and what he thinks of it. That is his view. And it doesn't appear an incorrect view to me. It appears quite accurate. Because in the press release that you showed me earlier, and it was said here in evidence, there was reference of a private group that was looking at private prosecutions. And that's precisely the point, that however normal government work was being done, there was always a risk that there would be others in society who would have their own reactions to that or have their own interest to pursue their own agendas, whatever those agendas may be. But the overall impact of all of that is that it would impact on the government program of social cohesion and post-TRC prosecutions. So if indeed what Mr. Picoli described, according to him, is what appeared to be likely going to happen because of those that were raising those things, he's actually correct. That's part of a risk assessment. And that's part of what the DGs in the cluster considered, and also what the cluster would have had to consider in terms of a risk assessment. So even the NSC would have then given a mandate to security services to say, do a threat assessment about what the likely impact of anything that is being undertaken is going to be anywhere in the country. And if there indeed is that kind of thinking somewhere, and it appears on the record that there actually was that kind of thinking, then that would have needed to be taken into account. And the problem with this kind of approach of a private prosecution of post-TRC matters, it's basically privatizing the kind of work that should actually never be privatized, if you think about it, in that it's best that type of matter is handled by government, whether you agree with it or not, because at least we can all accept that government is acting within the Constitution on behalf of everybody. But when a private person starts, or a private grouping start engaging in private prosecutions on those kinds of matters, what you're likely going to have, you're going to have others responding to them. And they may not necessarily respond with an intent to prosecute. They may have other intentions. So those are the risks that the cluster would, as part of its job, would inherently have to consider and flag that, have a note, in this location, there's something like this happening. So it became part of that kind of problem. And in the context where people had people from different groupings, nobody would have some accuracy about how the information is flowing. So at the minimum, there would need to be some guidance from some, at least formal structures like intelligence services, advising of what they see so that those issues are considered. So I'm imagining that Mr. Picoli was speaking to that kind of threats, and I'm saying I agree with him that his assessment would actually be at least accurate at a minimum, as worthy of reflecting.
Yes, just anecdotally on the question of private prosecutions, it reminded me of the judgment of Judge Lekhodi when he set aside the prosecution policy amendments because the Minister of Justice had argued that the amendments didn't undermine justice because even when there was a refusal to prosecute on the criteria listed, families could still seek to bring a private prosecution. And he made the point that the primary responsibility of prosecutions was not with private people, but with the state.
Yes.
And you agree with that?
Yes.
So yes, and in fact that's the view of Ackerman and Picoli, as they've testified before this commission, is that their attempts to go after apartheid-era officials were essentially stymied because it could potentially give rise to calls for prosecutions against ANC people. That's what they have repeatedly said.
That's fine if that's what they've said. I'd be keen to see the evidence of that, but I understand why they would say that. I don't necessarily agree.
Yes,
Yes.
We'll get to that in due course. All right, let's jump to paragraph 53 of your main statement. Now, here you state that the NPA quite clearly had investigative capacity in respect of the TRC cases. And you give the example of the NPA having met with the Reverend Chikani. Can it be clearly said that the NPA had any investigative capacity? I mean, under law, are they allowed to investigate?
Well, as at when the DSO was dissolved, they had, but after that, they definitely didn't have in law.
Yes. Now, certainly the DSO was the exception. That was an entity that was imbued with investigative
Yes.
power, and they had their own investigators on board.
Yes.
But the PCLU was separate. It was part and parcel of the NPA itself. You accept that they have no investigative authority or capacity?
No, remember that during well, of their own, no, definitely no. But because they were in the NPA, they could be assisted by the DSO whenever that could happen, yes.
Yes. Well, I don't want to go down that particular road because those controversies, I think, happened before you became DG. But you're aware that through the 2000s they struggled to get
Yes.
investigative support.
Yes.
And you also accept that under law, strictly speaking, they're not allowed to investigate.
Well, it depends. They're not allowed to investigate in the way we understand investigations because the police would do that work for them. That's why they needed the police. But
Yes.
they were certainly able to meet people and take their statements and their affidavits and get them commissioned. So that in itself is, in other words, in some cases from what Mr. Ackerman had described, they were able to do what otherwise would have been done by an investigating officer. So that's what I refer to, that in a way, although in law they didn't have to, but they were able to be industrious enough to obtain what they needed to be able
Yes.
to do the minimum.
And I like the word industrious because I think that does describe how how individuals in the PCLU, such as Advocate Ackerman, Advocate Mtunzi Maga, they were quite industrious in trying to do what they could in the absence of investigators.
Yes, no,
as you say,
accept
like having statements commissioned and carrying out inquiries that they could. And in fact, they did take some cases forward, even when they didn't have investigators on board, I think to their credit. Would you
Yes,
agree?
that's correct. That's correct.
But both Ackerman and Maga and McAdam as well say that they could only take it so far. And we heard very compelling evidence from Advocate Maga. He tried very hard to take it as far as he could. And he did knock up one or two successes, but eventually without investigators, he wasn't able to take it further. And he testified that out of frustration, he asked to be removed so that he could get court experience in the Transkei, and he eventually asked to be seconded to the Commercial Crimes Unit. Doesn't that give an indication of the struggles that they had?
No, the struggle, for the reasons that was indicated, that we understood. And that's why, at least at a minimum, the issue had to be resolved between the NPA and the police, which is what we did. It's just that it couldn't go further beyond that because of other events.
Yes.
But then, sorry to interpose, Mr. Vani, what then did you mean by saying they did have investigative capacity?
What I meant that if they wanted a statement from somebody, from their own evidence and what they told us, they were able to go and get that particular statement so that they
And
could move
is
the-
that the capacity you are alluding to?
That's
Because
what I'm-
investigation, as you know, as a lawyer, goes far beyond that.
That's what I'm talking to in the sense that, Chairperson, in the sense that at least they would be able, for want of a better expression, to move the needle to the extent that they could with what they had. But indeed, a lot more will depend on capacity they didn't have, that they needed from
So they
elsewhere.
didn't have a particular capacity. You acknowledge that?
Yes, that's correct. They
Yes.
didn't have that, yes.
Thank you, Chairperson. Let's move to paragraphs 55 and 56. And here here you state that in terms of the NPA, and I assume you meant to say the NPA Act, the authority to take a decision to prosecute this in the DPP with jurisdiction and no one else. And then you give the example of the DPP in Pretoria. But am I not right in saying that in relation to the TRC cases, that the proclamation, which was issued setting up the PCLU, vested prosecuting authority in the PCLU, or more specifically in the Special Director of Public Prosecutions? Commissioners, we do have the proclamation as part of the bundle. It's at page 722. Do you accept that in relation to the TRC cases, it was the PCLU that actually had authority to prosecute?
Yes, specifically, yes.
Yeah. So the comment in paragraph 55 that it vested in the DPPs and nobody else, at least in respect of the TRC cases, that's not quite correct, at least at that time.
Yes, yeah, it's not quite correct. Except that naturally for the work that the PCLU would be doing in the courts, the DPPs with jurisdiction would also provide whatever additional assistance that the PCLU would need.
And in addition to that, the actual amendments to the prosecution policy, and that's actually in Bundle 1, It's annexed as FA 27, page 537. And just to save time, I'm going to, I think you do have bundle one. It's one, I think, the other big file. And you're aware, of course, that the amendments dealt exclusively with the TRC cases.
So is it page 5?
It's page 537.
I don't know if I have the right bundle. I don't think I have.
Bundle one is the other big bundle with you.
Yes, I've got Appendix A. Sorry, no.
Yes.
537, yes, Appendix A.
And if you turn to Part B, which says procedural arrangements which must be adhered to in the prosecution process in respect of crimes arising from conflicts of the past. That's at 539.
Yes.
And I'll just quote to you paragraph 7. The NDPP must approve all decisions to continue an investigation or prosecution or not, comma, or to prosecute or not to prosecute. So the amendments to the prosecution policy seems to be vesting authority in the NDPP himself to decide to prosecute or not. Do you have any comment on the fact that the prosecution policy appears to be vesting that authority in the NDPP himself?
To continue an investigation, yes.
Yes, to continue an investigation or prosecution.
Or to prosecute or not to prosecute, yes.
And then comma, or to prosecute or not to prosecute.
Yes.
Is that not in conflict with the NPA Act and the Constitution?
That it does that.
Yes,
It seems to reserve only to him,
yes.
to an NDPP. I think it would. I think it would, because if I recall, I haven't read it in a while now, but if I recall, I think the decision to prosecute, at least to initiate a prosecution, also vests with DPPs.
Yes, that's correct. And indeed, it's one of the reasons why the amended policy was seen as manifestly unconstitutional. And then let's turn to paragraphs 57 to 59.
Can I close this bundle? Can I close this bundle?
You can close that bundle.
Okay.
Yes, yes.
Make sure that's not done.
Sorry, we're back to your
Yeah.
October 25 statement. Apologies for that. So, in these paragraphs, you deal
59.
with the question of interference, and you state that if any prosecutor was stopped by me, I imagine that this would have been reported to the minister, and you're not aware of, of any such matter being reported to the minister. And then you also say in paragraph 59 that you're not aware of the DG cluster being involved in stopping or attempting to stop any prosecution. Now, you were part of the of that DG cluster. Am I not correct in saying that in February of 2007, some members of the of the DG's forum or cluster, whatever you wish to call it, took the view that the NDPP would have to wait for a recommendation from the task team and then the DGs before proceeding in any TRC case. Does that not amount to interference in the discretion and work of the NPA?
No, definitely not. No, it does not.
So even though the hands of the NDPP are being tied in a sense, because at least in the views of the SAPS, the NIA, and as I understand the DOJ as well, he had to wait to hear, the matters had to be discussed in those fora, and he had to wait for a recommendation before he could act. And indeed, he was severely criticized for doing so because, at least in the one case, he went ahead without the recommendation, namely the Chikani matter.
No, I don't agree. I think the issue, as I recall, we discussed it. I know that the National Commissioner engaged separately with the NPA through Mr. Jacobs as their proposal. But what we were discussing was how to engage with the processes, where we would be able to indicate the views of the cluster, if the cluster obviously agreed with the approach that it was intended to be presented to it. And the idea was to put all the risk elements and risk factors on the table so that whatever decision the NPA takes, it takes it knowing of all of the factors that pertain and the impact. That is what the DGs were discussing.
So I want to put the then National Commissioner's letter, National Commissioner Jackie Celebby's letter to you. It's at page 715 and 16 of the cross-examination bundle. It's dated the 6th of February, 2007.
715.
715. So it'll be towards the back.
Okay.
It'll be in the supplementary bundle towards the back.
Yes, I have it.
So it's and you're aware, of course, that the same letter was addressed to Advocate Picoli as NDPP and the other members of the DGs, and this particular one was addressed to you. So in the first paragraph, he talks about being briefed on the last meeting of the task team. He then makes reference to the Chikani matter, where he says a decision on prosecution was taken without consultation with the respective departments. Paragraph 3, he writes, I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Directors General will have an opportunity to provide input before a decision on prosecution is taken. He then says he's under the impression that there's no common understanding on the process to be followed. And the last paragraph on the page, my understanding was that the officials designated on the task team by the DGs will provide recommendations to the Directors General, who will as a collective advise the NPA as the decision maker on prosecutions. And if you turn to the next page, he refers to a report that he says should be discussed by the DGs. Next paragraph, Although I do not insist on a meeting of the DGs after each meeting of our officials, I deem it necessary that the substantive reports and recommendations of the officials should be discussed by the Director General before a decision is made. And that decision is a prosecutorial decision. So I want to put it to you that it's abundantly clear that Jackie Celebby, as the then Commissioner, had in mind that before the NPA could make a prosecutorial decision in a TRC matter, it had to be discussed by the officials in the task team as well as by the Directors General, and a recommendation had to be made first. You would agree that that is exactly what this letter is saying?
I understand that's what you had in mind, yes.
Yes. And then you responded to that letter.
Yes.
And this is the letter that is, I think, freestanding. I think a copy should be on your desk.
Yes, I've got it, thank you.
It's a letter from yourself to the National Commissioner. It's dated the 7th of February, 2007. You refer to the Commissioner's letter. You state, I am in agreement with the sentiments contained in your letter. Indeed, I was also expecting that the Director General would be consulted formally in a meeting on the decisions regarding TRC cases. I'm not going to read the rest, but it's apparent that you agreed with the National Commissioner on that question.
Yes, on the consultation process, yes.
Yes. So the response of Advocate Picoli, as I think you're probably familiar with, is that this constituted an unwarranted interference in the work of the NPA and undermined the independence of his office. And in fact, he did report this question to the Minister. He did so in February of 2007. Commissioners, that secret memo that he wrote to the Minister is in bundle FA 33 at page 553. And in that, I'll just wait for you to...
Sorry, what bundle was that?
It's in bundle 1.
Bundle 1.
Yeah. It's a long memo. I'm not going to read it into the record. But the gist of his secret internal memo, dated 12 Feb of 2007, to the Minister, he says it's clearly a misunderstanding, and this is a paragraph 5.1 on page 562, that there's a clear misunderstanding regarding the role of the task team and the role of the relevant state departments referred to in the amended prosecution policy. He says in the same paragraph, the National Director should never be in a position where his constitutional duty is dependent on the recommendation of such a task team or relevant department. Such a procedure would be unconstitutional. Do you not agree with Advocate Picoli's concern?
I don't agree with his concerns. I think his concern is legitimate in that if that was his interpretation of what he thought was going to happen or was happening, is entitled to have that view and share it. It's just a pity we never got to meet and actually have a discussion about what the issues were that were going to be discussed by the DGs and presented to him for recommendation purposes. But it was definitely not to get in the way of a decision to prosecute or not to prosecute, or to investigate or to not investigate.
Yes, but Advocate Simelane, surely the letter of the Commissioner, which we've discussed, says just that, that the NPA, before it can make a decision, is dependent on a recommendation from those bodies, and that procedure is manifestly unconstitutional. Does it not violate the constitutional independence of the NPA?
I don't agree with you. We haven't discussed this letter. Maybe let's discuss it. If you look at the context of that letter, it deals with general concerns about which we've already discussed, and the chair and the commissioners asked questions about the broader context issues. And those issues remain at every stage. That's the first thing. The second thing is that the letter of the, I'm not speaking on his behalf, it's just my interpretation. The letter of the National Commissioner also talks about the task team, his own understanding of what the task team was supposed to do. But generally, what I do recall is that the members of the task teams that we sent forward were to communicate and engage our issues, like myself as the DG, they would do the same into the task team, feed into it, engage, and give feedback, which would be discussed in the cluster one way or the other. So the task team members were already doing that kind of work, of engaging. So this was a continuation that once all the feedback in a way has been received and the other departments have done their work and they've produced reports, we should be in a position as the DGs to discuss those particular reports, make an assessment of their impact, and then be in a position to inform the NPA and the NPP about what we particularly see. And our preference was that we would meet with the NPA, him or whoever you designate for that purpose, to engage on those particular issues, and ideally prior to them taking the decision. It would not make sense to engage after the decision is taken, because in most cases the horse would have bolted. So if there are security risks that need to be mitigated, ideally you want to deal with mitigation factors before a decision is taken, because once a decision is taken, it becomes a public issue, and those who need not be alerted of what is happening then become alerted, and that may undermine security and intelligence. So the idea was to make him and the NPA aware that, by the way, before you take your decision, it would be of great assistance to yourselves if you are aware of what we see from our end. So that is what was intended in this communication, to say, let's have a discussion about it, and let's convey that, firstly, as DGs, and agree. That's why the meeting was proposed to take place, so that once we concretize that, then have a framework in terms of which that is communicated to the NPA. But what would have happened is that that proposal, in other words, the National Commissioner, if we had agreed 100%, would have then had to put a proposal together that would have submitted to the cluster, so that the cluster gives approval for that kind of thing, and then it goes forward. The fact that it then at the same time engaged and communicated to the NPA is another issue. I would have preferred that he didn't do that, but he chose to do it. But even then, with that in mind, in my view, respectfully, that is not a problem, because all that was required is that everybody meets and discuss what the issues would be likely to be, what the implications would be, and whether then that would work or not. So whether there would be agreement on it is something we can only speculate about, but at least at a minimum, there ought to have been an engagement, and that we're entitled to do by law.
Yes, but nothing of that changes the stark fact that his decision was dependent on the inputs or recommendations of outside bodies, and the Constitution and the NPA Act does not permit that. Do you accept that?
No, I don't accept that it was dependent.
Okay.
I don't accept it. It could never be dependent.
Yes,
because you could make a decision whenever an NDPP makes a decision. We would plead and insist that at least talk to us so that these issues are put on the table. for argument's sake, let's say an NDPP would have said, it didn't happen in this case, but just hypothetically, let's say an NDPP says, I don't even want to hear from anybody, I'm not interested. We would have then had as a cluster to respond to it in terms of what the implications are of that kind of environment. And invariably what it would have meant is that in addition to planning for other people, we now would have had to plan for one of our own in case they move in a way that is, in a way, unexpected. So the idea is that if at least everybody's in sync, and what I would have expected to hear is that somebody would say, well, it's fine, we'll make your decisions, but ideally, in order so that we are not affected, whatever you have to say, your report must reach out by such and such a time, for argument's sake. That would have been quite in order for me, because that's all that the DGs were talking about. But to say you have no say whatsoever at all, I think that in itself is not constitutional.
Yes, well, I must put it to you that your explanation amounts to a fair measure of sugarcoating, but none of it can get around the stark fact that in the Commissioner's letter, in 2 places, he said plainly and clearly that the inputs had to be made before a prosecutorial decision is made. And as a result of that, Advocate Picoli, the NDPP, I'm going to quote to you 2 paragraphs. He says, in paragraph 5.2 on page 563, and this is in bundle 1, that separate bundle if you want to look at it. I have now reached a point where I honestly believe that there is improper interference with my work, and that I'm hindered and obstructed from carrying out my functions on this particular matter. Legally, I've reached a dead end. 5.3. It would appear that there is a general expectation on the part of the Department of Justice and Constitutional Development, SABC and NEA, that there will be no prosecutions and that I must play along. My conscience and oath of office that I took does not allow that. What is your response?
No, I can understand what he's saying. I mean, that's his view. That's how he experienced the communication. All I'm simply saying is that he jumped to that conclusion. It certainly is not what was intended, as far at least as I recall. That's not how I am interpreting the letter by the National Commissioner and the context within which all of these issues were being discussed anyway. And a simple engagement with the colleagues, he says he thinks there's a great misunderstanding. Well, maybe there was, but on his part, there appears to clearly be one, hence his communication, because that's how he experiences that communication. That's not how I experience the communication, and that's not what I understood the National Commissioner to be talking to. What was always intended is that all the risks that pertain, as I described for the Commissioner in explaining the national security issues, it was always important, and to this day it remains important, that if there are issues of that nature, it is important that the NPA and the decision makers become aware of what the implications of their decision is likely to be on the rest of society. There's no interest on the part of the cluster on the actual decision to prosecute those individuals, but on the subsequent implications. Those things do matter, and they have to be taken into account. And there's plenty of examples to look at where such things have been done in the past, and even though they are done, sometimes they don't necessarily achieve what is intended, which is to prevent them from happening. Things just do happen because society has its own views, but those things must be mitigated by some people. And as DGs in our areas of work, then we were responsible for making sure that that happens. I was responsible for making sure that the NPA is assisted to work. So I had my own fight with my own DGs colleagues to say this must happen, because I spoke for the NPA in the cluster. They had their own considerations which they had to take into account. So all that this needed was just adults in a room to sit and talk. It just didn't work as we would have liked naturally. But that's the context of these communications.
Chairperson, it is 1 p.m. Would this be an appropriate time for the lunch adjournment?
Yes. We'll take a lunch adjournment and reconvene at 2 o'clock.
As the Commission pleases.
Thank you.
Mr. Vani?
As the Commission pleases, I just want to check, Commissioners, can I be heard? The rain is so loud, I'm hoping that...
You can barely be heard.
Okay, I will try to raise my voice as loud
Yes.
as I can.
You must compete with the elements.
Yes. Commissioner, if only I could, then all my problems in the world would be solved. Advocate Similani, before we adjourned for lunch, we were about to wrap up your statement of October last year. And so I just have one more question in relation to paragraph 58. And can I just check, Advocate Similani, can you hear me?
I can hear you. I can hear you, yes. Barely, but yeah, I can. 58, yes.
So once you have paragraph 58, you'll see that you comment on the suggestion being made that a request to remove Ackerman from playing an active role in the investigation and prosecution of post-TRC cases is tantamount to stopping prosecutions, and in that paragraph you reject that suggestion. The families take a different view. They see the removal of Advocate Ackerman from the TRC cases, at least from the side of the operations, as one of the several factors that serve to undermine the TRC cases. Now, the last matter that Ackerman pursued before he was removed from the TRC cases was the Chikani prosecution, which resulted in a plea bargain in August of 2007. Now, if the removal of Ackerman was not tantamount to undermining the prosecutions, how does one explain that following the Chikani case in 2007, there wasn't a single prosecution or a TRC-related inquest that was held between 2007 and 2016, a period of some 9 years?
Well, the prosecutors must explain that, because the prosecutors are the ones that, and they would have told you that they are the ones who are responsible for taking a decision to prosecute. After which decision is taken, they are the ones who are responsible for placing the matter on the roll, on the court roll, or removing it, as the case may be. Only they do that and nobody else. I'm not aware of any case, at least during my involvement, where a matter was decided to be prosecuted and somebody stopped it, or a matter where it was about to be placed on the roll and somebody caused for it to not be placed on the roll. So I'm not aware of facts that actually stopped the act of doing what a prosecution official does. If there were, I'd be able to comment on that. So that's my first comment on that suggestion. The second suggestion regarding the removal of Mr. Ackerman per se, it could never, in my respected view, cause for any matter, even a matter he was himself handling, to not be able to proceed. It may delay it because a replacement would have to be found who needs to catch up. These things happen all the time. In normal cases in courts, counsel gets changed, a new counsel catches up with the papers. So that is what would have happened. I don't recall in my time where it was indicated that somebody in the NPA or the NPA itself could not prosecute a matter solely on account of Mr. Ackerman being removed from leading cases. The contrary, though, is that his presence was a source of concern for many others, and I think the matter of Mr. Chikane indicates that. So I dispute a statement that suggests that Mr. Ackerman's removal is a sine qua non for matters not proceeding in any way whatsoever. I find that difficult to
Yes.
believe.
Thank you. Of course, in argument, we will be making the point that it contributed to the undermining of the cases. And I should add that the only question why, the only reason why the matter in 2016 was enrolled, that was in relation to the disappearance and murder of Nokatula Simalani, was because Tembi Simalani brought an application in 2015 to compel a decision in that matter. Do you recall that application?
I wasn't involved. I only recall from reading it in the media, yes.
Yes, but
I wasn't in the system.
you heard subsequently, I'm sure, that
Yes, I was aware
she
there was
did bring an
some of that,
application
yes,
to
yes, I
compel
was
the
aware of
decision.
that.
And just as a matter of interest, what's your reaction to the fact that a family such as the Nokatula Simalani family had to bring a substantive application to court to extract a decision out of the NPA?
Personally, I think it is regrettable that families and any other group of people, individuals included, who feel aggrieved by TRC processes are put in a position where, in respect of their matters, there is no closure to this day. That I find regrettable, that it would need to go that far.
On that score, we agree with you.
Yes.
Before we move to your supplementary affidavit, this morning we had a discussion around whether the pursuit of cases against former apartheid officials would open the door to calls for cases against the ANC. And I think your response was, well, you're not aware of any such evidence. I just want to put one extract to you, and this is in bundle 1, so it's the other big file. Bundle 1 at page 97, paragraph 225.
Yes.
And in fact, let's start on the previous page, 96, at paragraph 224. And here we're relying on the affidavit. Mr. Kalatu, who made out this affidavit, is relying on Advocate Picoli's affidavit that he filed in support of the 2015 application brought by the Simalani family. And he then quoted from the affidavit he filed before the Gunwala Commission. So paragraph 224, he says that later in 2006, Picoli was summoned to a meeting which was convened at the home of Minister Zola Skweyiya, then Minister of Social Development, and it was attended by various other cabinet ministers and others, including Minister of Police Ngakula, Minister of Defence Lakota, Toka Didiza, Acting Minister of Justice, and a Mr. Jafta. And the subject matter was the Chikane prosecution. Then if we can turn to paragraph 225, and I quote, "At this meeting it became clear that there was a fear that cases like the Chikane matter would open the door to prosecutions of ANC members, and then we quote from Picoli's affidavit before the Ginwala Commission, and I'm only going to quote one paragraph. And incidentally, Commissioners, that affidavit is in bundle 2 at page 1, and the quote is at page 12. And the paragraph in question is as follows, and this is Picoli's recollection of that meeting. The Minister of Social Development was concerned about the impact of the decision to prosecute on the ranks of ANC cadres, who were worried that a decision to prosecute on the Chikani matter would then give rise to a call for prosecution of the ANC cadres themselves, arising out of their activities pre-94. So according to Advocate Picoli, back in 2006, Cabinet Minister was raising those concerns. Your response?
I can't respond. I don't understand this concern, but because I don't know anything about this meeting and its context, I won't be
Yes.
able to comment this.
It's only put to you because you said you were unaware of any evidence to support this contention. And so I'm putting this extract to you to show that there is evidence supporting that contention.
I understand.
All right, then let's turn to your supplementary affidavit. That's your affidavit dated 28 March 2026. Commissioners, in the cross-examination bundle, that's between pages 44 and 62.
Yes.
And let's jump to paragraphs 22 to 25. And there you deal with the allegation that, or contention that you instructed acting NDPP in Share to remove Advocate Ackerman from the TRC cases. And I just want to put to you an extract from the testimony of Advocate in Share, and this has been distributed. I believe it's lying on your desk. It's the transcript of the evidence of Advocate in Share before this commission on the 7th of April 2026.
I don't know if
It is a loose document like this,
Oh, this one.
Yeah.
Okay. Thank
and
you.
if the
Yes.
commissioners also have a copy.
Yes, it's the
Yeah.
one. Yes.
Page?
And it's page 55, Chairperson. And Advocate Salukazana, who was leading Advocate in Share, towards the top of the page, says, I want to direct you to the statement, one that starts with, I can only speculate. Is the speculation reasonable that the probabilities are high that Mr. Simelane asked you, being Advocate in Share, to remove Mr. Ackerman? And Advocate in Share responds, the speculation, as he states, for me recalling, is not improbable, and I would substantiate that. It is because that happened to me as well in passing. It was not in a meeting. It was not written anywhere. But I recall that I was with Advocate Simelane, who just remarked to me and said, hey, Chief, why are you keeping Ackerman there? So that is why I say that speculation may be closer to what happened. So there you have Advocate Mshare saying that you did have an encounter with him, where you did ask why he was still keeping Advocate McAdam in charge of the TRC cases. Do you recall that?
No, I don't recall that, no.
Okay. Do you dispute it?
I wouldn't dispute it. I just don't recall it. But maybe I can explain. If it would have happened, it would have happened having made an observation that what Mr. Picoli had agreed he was going to do had not happened. That would have been the context. But I don't think it happened because I would have had no reason to raise it, because we had achieved as a cluster what we wanted to achieve. So anything else after that meeting had not been brought to my attention, either in the cluster or in the forum of DGs, that would have necessitated that matter be followed up. So I would not have done it. That's why I don't remember it specifically.
Well, the issue would still have been in play because, as I understand it, the deliberations that you're referring to was back in or around 2006. And Advocate McAdam, at least Advocate Ackerman, was still in charge of the TRC cases well into 2007. And indeed, it is the evidence of him share that he was only relieved of his duties in November of 2007. And in fact, Advocate Mshare thinks it might only have been early in 2008. So certainly through 2007, that issue was still alive.
No, the issue that would have concerned me, that would have needed to be alive then, would be a complaint to the cluster that cooperation between the NPA and the police continues to be a problem. After the meeting that we had, that issue never arose such that it needed to be followed up on. So I would have had no reason to follow up on the matter on my own, just like that. I don't think so. And if it had also arisen, it could have been Mshare himself that maybe would have wanted to find out from me where the debate comes from. I'm just trying to speculate why him and I would have had to talk about a matter that I had considered at least had been resolved based on what was discussed in the meeting. I just don't recall it specifically.
Yes. Well, we note that you don't recall it and you don't dispute it, and in fairness, I must put it to you that we will be putting it to the Commission that the evidence of Advocate Mshare in relation to that encounter should be accepted.
That's fine, I note that.
Earlier when we were talking about the question of delivery on the TRC cases, and I made the point that there had been no enrollments in court or inquests in relation to TRC cases between 2007 and 2016. And you pointed out, and I take the point that you were not there for that full period, although you were in DPP between 2009 and 2012.
Yes.
But according to our records, no prosecution was launched while you were in DPP or inquest reopened in the years 2009, 2012.
Yes, not to my recollection. But what I was aware is that work was being done on those matters. At least those that were there, that were mentioned.
Yes, but that's a period of some 3 years. What explains in 3 years that there's no enrollment and no inquest proceeding while you're in DPP?
Well, the reports that one got in the normal course is that matters are currently under investigation from the various individuals. So none was ready of the type that needed to go forward. At least I wasn't informed that there was anyone that was ready that the PCLU were now enrolling in court. That would have been the only reason why. So my assumption is that, like in all matters, they remain subject to investigation or some other form of processing.
But given that you must have been aware that these were old cases and had been subject to much discussion when you were Director General of Justice, certainly towards the end of your term. Did you not raise a concern or raise the alarm as to why no cases were being enrolled or launched?
No, I didn't think there was a need to even go that far. The important thing was that work was being done on them. And I had no complaint in front of me against any official for not doing their work properly. You know, the kind of complaint that would have required me to get involved and intervene. The relevant deputy national director who was briefing me and was attending to the matters, I imagine would have mentioned if there was what I can call a problem to be attended to. So the fact that there was that history, yes, is problematic in the ordinary course of events, but the fact that some progress was being made, to me at least, was sufficient to leave the matters as they were and await the finality of those matters.
Let's jump to paragraph 45 in your supplementary affidavit. And there the question of the vetting of Ackerman, you discuss it. Ackerman had mentioned that he must have been vetted, but you say at about the 5th line, you take no issue on this aspect. I simply state that a vetting at this time, or that time of our country, would not have prevented him from being appointed. It must be recalled that government and those in political leadership across all parties had implored on South Africa to accept, despite the pain of the past, and embrace reconciliation and to work towards nation building. Now, the concern I have with that statement is that if in fact...
If I may interpose, Mr. Vani, what paragraph are you?
I beg your pardon, it's paragraph 45
45.
of the supplementary affidavit.
Yes.
And that quote is about from line 5 or 6 down.
I've got here in paragraph 45, it's the heading under G, it's government structures, the JCPS clusters. So we are not on the same page.
It's page 54 of that bundle.
Yes. There is a duplication of paragraphs.
Oh, is there duplication? My
Yes.
apologies. So my question, Advocate Similani, is are you suggesting that Ackerman's background was overlooked because of the need to pursue reconciliation and nation building, particularly since your evidence in your main statement is that there were serious question marks hanging over Ackerman's background as an alleged apartheid prosecutor and someone who had links with apartheid operatives. Surely a vetting process would pick up those issues before somebody is appointed to probably one of the most sensitive prosecutorial positions in the country at that time.
You want me to comment?
Yes, please.
Oh. No, my comment here is in relation to at least what appeared to me to be Mr. Ackerman making an issue of the fact that there was some vetting. In fact, there wasn't necessarily a vetting as far as I know. He thinks, from what I followed, he was saying that those in the cluster who were opposed to him shouldn't have and were unfair in being opposed to him because, according to him, he was vetted. And if there was a problem with his vetting of the type that it was deemed he should not be appointed, he would not have been appointed. So he says he must have been vetted. So all I'm simply indicating here is that you can be vetted and still be appointed even if there are reservations. A vetting on its own, even if you don't necessarily pass it, does not mean you wouldn't necessarily be ultimately appointed. There would be other considerations that are taken into account by those that are responsible for the appointment to have done that. But I'm simply putting the point that if he was vetted, he would know that he was vetted, because a vetting of the type he was suggesting he has, which is a top clearance, top secret clearance, would require that he undergoes a polygraph. So nobody forgets going through a polygraph. So he should not have said, if he had gone through a polygraph, he would not have said, I must have been vetted. He would have said, I was vetted. But what I'm simply indicating here is that that's fine, but that's not the biggest issue. The vetting or otherwise is irrelevant. He could have been vetted, gone through a polygraph, passed, got a top secret clearance, and still his colleagues refused to work with him for reasons that would have needed to be described. So what would have happened in this case, assuming Advocate Picoli had not agreed to remove him, what would have happened, and I don't know if I cover it in the statement, the matter would have gone to the cluster. It would have been reported to the cluster that there is a problem. And then the cluster in its deliberations is likely would have wanted to know the details you were asking me earlier, to say, okay, those who are so fundamentally opposed, is there a way in which they can take everybody into their confidence about what is so fundamental an issue? It likely would have gone there. But I'm saying it didn't go there because Advocate Picoli, in a way, was magnanimous and accommodated everybody, just so that the issue could move forward. But if he hadn't, it would have gone to the points that you are asking for. That's all I'm trying to explain around what vetting, in my assessment, meant in that context of what you were saying.
But do you accept that the concerns raised in relation to Advocate Ackerman as to why he shouldn't be in charge of the TRC cases, that they were baseless concerns?
No, the concerns of that nature to me can never be baseless.
And yet you and your colleagues haven't put up a shred of evidence to indicate why Ackerman should be disqualified from handling those cases, except for general claims about having prosecuted under apartheid.
Well, I wouldn't have had to put up that kind of evidence because I wasn't the one necessarily opposed to him. I was just a facilitator of a meeting, firstly. Secondly, as I said, if the issue had developed to the point of being discussed in great detail, that kind of information would have needed to be brought up. Whether they would have done so or not, I don't know, but there would have been a requirement to say, let's engage, please produce information. Simply because, just because people oppose somebody, you don't just run with it. I mean, you give due process, you engage, that kind of thing. All I'm simply saying is that, yeah, we were actually lucky in the debate of the issue, in that Advocate Picoli accommodated those who were concerned. If he had not, then the issues you're talking about would have been ultimately gotten to. But it can never be baseless. And from what I recall in the engagements, there are many things I wouldn't say here, but people were pretty serious about ensuring that Mr. Ackerman doesn't proceed.
Yes, but as we sit here today,
Yeah.
Not a single fact has been put up, and yes, I know this is coming from your colleagues, but at the time, not a single example, not a single fact, simply nothing was put up to warrant his removal, and so the conclusion is inescapable, since no facts were put up, that the decision to remove him was based on absolutely nothing. It was absolutely baseless, and there's no getting around that.
Well, that's not true. It's not accurate. And it's not possible that anyone can reasonably reach the type of conclusion that you are suggesting in the context of what you've discussed about TRC matters, in the sense that lack of trust alone is enough for anybody to raise as a type of concern that nobody would want to engage with anybody. And that trust here is based on the fact that Mr. Ackerman was an apartheid prosecutor who had reached in his career one of the highest levels of appointment under the apartheid government. That is a fact. So those who engaged with the system at the time, who experienced being prosecuted under an attorney general of any province for that matter, assisted by a deputy attorney general in the name of Advocate Anton Ackerman, would lack trust in people that engage with that system. That is sufficient on its own to make sure that Mr. Ackerman doesn't come anywhere close to matters of this type. So that is a fact.
Well, the facts don't seem to support that, because as far as we're aware, by 1994, Ackerman was simply a senior state advocate. He wasn't particularly high in the NPA.
I'm not sure that I was speaking about the same Ackerman, because Mr. Ackerman, as head of the PCLU, was a special director.
Yes, he became a special director in 2004, but we're talking about his status by the end of apartheid.
Well, what was understood is that he was that senior in an AG's office. I mean, again, that can be double-checked, but the fact of the matter is that his seniority and his level of engagement in prosecutions, irrespective of a court, it can be regional courts even, was of a nature that he dealt with matters that affected liberation movement fighters. And that is enough for those who were involved in those processes to not trust him enough to want to work with him going forward.
Incidentally, you mentioned that Picoli agreed to remove him from the cases. Is there any evidence that Picoli took that step, to your knowledge?
Well, I'm not aware. I was never informed if he followed through on his decision. But for purposes for which I was tasked, it was enough that he agreed to do so and the meeting ended. Because I had to deal with something else as far as the cluster is concerned, and not Mr. Ackerman. He was not my subject.
Well, as I understand it, the meetings in question, according to your evidence, were in or about 2006. And throughout 2007, only towards the end of 2007, was he relieved. So in fact, there's no evidence that Advocate Picoli removed him from the cases, because it was actually only Advocate Mshe who removed him from the TRC cases.
Sorry, Chair. Sorry. I think it's not a correct presentation of the evidence given by Advocate Picoli himself when he spoke about how he managed the problem that he was facing with Mr. Ackerman being the head of the TRC cases. The evidence of Picoli is in the transcript. I'll just find the specific area, but in the transcript, Advocate Picoli specifically said that he, in order to keep this noise off his back, he decided to remove him. And Dr. Ramaite became the head of the leader of the TRC cases in the PLC. So it's not correct that what my learned friend is putting and I will find the paragraph in the transcript I had it yesterday. That transcript, I read it yesterday because I anticipated he would ask that question.
Yes.
So I'll put that
Mr.
question
Masugu, I think you'll be able to deal with it in re-examination, but let the witness respond. I'm sure you will be able to respond to the question.
Chair, the only problem is being asked on incorrect facts. It's incorrect to put it to a witness that this was the fact, when in fact it was not the fact. That's what I'm objecting to. I can deal with it in re-examination, but it's not appropriate to cross-examine a witness on incorrect facts.
Mr. Vani?
Well, I invite my learned friend, Mr. Masuku, to find that evidence and put it up in re-examination because we're not aware of it.
I can actually do it now if that would help for you
Yes,
not to
that
lead,
will
not to,
help.
yeah. So if you go to the transcript of Picoli, which is on day 22, on the 13th of March 2023, in that transcript on page 153, just on top of 153, you will see that he says, Advocate Picoli says, no, the issue here is that, also I did earlier indicate that I had to choose my battles carefully. I did not want to cause any further delays, but I never removed Anton Ackerman from the cases. But what I did so that I'm able to eliminate this obstacle, Ackerman, and also knowing him to be, abrasive and can, cause you friction, because, a hardcore prosecutor can cause that, and I regard him as such. Tactically, for things to proceed, I am fine. Dr. Ramaite, to whom he reported, would attend those meetings, and you would be the one who takes a lead he would be the one who takes the lead in the discussion so that it is not Anton who is the face of the post-TRC prosecution, because that animosity would have continued and it would have caused further delays. So I never removed him because anyway, I did not have any authority because he was a special director appointed by the president.
Chairperson, the text speaks for itself. I don't know
Yes.
whether we want to waste time
Yes.
be responding to it because it's quite evident he did not remove
Yes.
Ackerman from the cases. He simply said that Dr. Ramaita would attend those meetings.
Would attend the meetings. Mr. Masugu, I'm going to rule your objection out of order, and I will ask the witness to respond to the question that has been put by Mr. Vani.
Thank you, Chairperson. Chairperson, to
You may rephrase your
perhaps,
question.
I suppose we do need to wrap that up. So the evidence of Advocate Picoli is that he never removed Ackerman from the TRC cases. And the evidence of Advocate Mshe is that he was the one who ultimately removed Ackerman from the cases. Do you accept that?
No, I accept that.
Thank you.
The point of the matter, though, and I think I must re-emphasize this, for me, that was never the issue. That was the issue for the other DGs insofar as it affected their cooperation. The issue of the cluster was whether or not the program continues. And if it's a result of lack of cooperation of the type I described, that the program was not moving, let that be resolved. But as soon as that was resolved, the way Advocate Picoli said, well, he made a commitment which, as you say from the evidence, he didn't follow up on. To me, that is not relevant because it did not result in the issue being raised again in the cluster of lack of cooperation. So if there was cooperation afterwards, the job was done as far as the cluster was concerned. Other issues had to be attended to by the departments with those with whom it was engaged, like the NPA.
Okay, let's move on. And I'm going to be referring to paragraphs 51 through to 55 of your supplementary
Mr.
statement.
Vani, I thought I could wait with my question, but Advocate Similane, what I cannot understand clearly is that let's say we accept for present purposes the version of Reverend where am I now? Sorry,
Chikani.
Reverend Chikane, I'm sorry, that there was an acrimonious event that happened, and Mr. Ntwe, who took the decision as NDPP or acting NDPP, accepted that version, it seems that was the trigger, or at least part of the trigger, why he was removed. But I can't understand why he was not only removed from dealing with Reverend Chikane's matter, and that he could go ahead with the other matters. To me, at least, it makes absolutely no sense, because throughout all the evidence, it seems that that is at least the basic reason. So it does trouble me that it could have been removed and to deal with only one aspect, sort of administrative aspect, and not the prosecutorial aspect of the matter. Does it make sense to you?
Well, it does make sense to me. I think I've explained what issue concerned the cluster, and it never arose again, and that would have been the end of my involvement. But to the point that Ackerman was then not removed, I've indicated that that did not seem to create a cooperation problem, because that issue was never brought again. So that's the end of what the cluster is concerned with. So what are you left with? What you are left with is the normal course of events. Do your investigations, do your prosecutions, and move forward. So the decision on who prosecutes is up to the NPA. So it should have been up to the others who were still opposed to Mr. Ackerman, if they still were, to say, despite what was agreed in our meeting, we see that Mr. Ackerman is still involved and we have a problem. If they don't say that, the cluster doesn't have to be involved, because as far as the cluster is concerned, that issue doesn't exist anymore. Let the matters carry on. And the issue of who the NPA allocates to conduct a specific prosecution is up to the NPA. So if he was allocated to prosecute, there's nothing anybody can do about it. The complainants, Mr. Chikane, or anybody for that matter, who would have needed or wanted to complain about that, would have been entitled to complain, and the NDPP would have had to deal with that complaint as it arose. So the choice of who prosecutes doesn't concern me, and would not have been the business of the cluster anyway. So if Mr. Ackerman was asked to continue leading that particular prosecution, that was one thing. What the cluster, the DGs in the cluster had a problem with was that he leads on TRC matters, not that he be removed as head of the PCLU. So if he was no longer leading on TRC matters, such that those departments felt they could then start a process of cooperating, that was the problem solved as far as the cluster is concerned. Then the detail as to what happened was not the cluster's business, so the cluster would not have concerned itself with that. So personally, I don't have a problem with Mr. Ackerman, and I would not have had a problem with Mr. Ackerman conducting specific prosecutions, because that would not have had an impact on cooperation unless made an issue by whichever department it did, and that never was brought to the cluster. So personally, I don't have a problem with it.
Yes. Thank you. Mr. Vani.
Thank you, Commissioner. Advocate Simononi, let's move on to paragraphs 52 and 53 of your supplementary statement. So if I may paraphrase, and please correct me if I don't get it right. You say that in a discussion of any proposal for which the support of the cluster would have been required, the cluster would have been interested in whether any support was meaningful for the purposes for which it was required. And then in the rest of that paragraph, you refer to, I suppose, the types of support, including the carrying out of investigations. And then in paragraph 53, you point out in the first sentence, discussion by the cluster would not seek to support what has been submitted, even if supported by a few DGs, if it had shortcomings. Now, the work of the PCLU on these cases, and we have to remind ourselves what these cases were. They were, almost all of them, I think without exception, were murder and kidnapping cases. Why should the support, particularly the investigative support for such cases, why would that be questioned? In particular, the proposition posed as to whether any support was meaningful for purposes for which it was required, and that potentially, if that request for support had shortcomings, it might be withheld. What possibly would cause the cluster to question why support was needed to investigate murders and kidnappings, let alone meaningful support?
I mean, in respect of TRC matters?
Yes.
Well, I can tell you that this happens in respect of all matters, even matters that are not TRC matters to this day. Part of the work of the cluster is monitoring that, through joints, is monitoring that the criminal justice system functions effectively. So capacity at all levels gets discussed, including the judiciary. So it would matter that if an issue of lack of cooperation had been raised initially as a problem, and now it is reported that it is no longer a problem because of whatever agreement would have been reached, and that cooperation is now in place, the cluster would, in its ordinary course of work, required to know how that support is being provided. So each department that provides support would account, firstly via the interdepartmental task team, in other words, what your member from social development is contributing to the task team. That would be required to be reported on to see if it definitely does assist the program. And there would be reports about what else is needed that is not there. So another department could be asked to contribute a member. So in this case, assuming all the departments were contributing correctly with their members, the cluster would be interested to know if it is adequate. So the NPI could say, they've given us 100 members, but they're all constables, and they're all new, straight out of college. The number is right, but the quality we're not able to work with because we have to manage these people. That would have been an issue for the cluster, to say, why are you approaching it that way? Where are the experienced people at different levels? That's what I'm talking about there. To say that the police would not have determined on their own what kind of assistance they provide. The cluster would have made contributions to what they could provide. So the police could come and say, sorry, we only have 2 kennels that we can spare. We don't have more. There would have been a debate about whether that is sufficient, and the NPA would have indicated if it's sufficient or not. That's the kind of engagement that would be there. But if it takes place at the cluster level, it's an indication that the cooperation is still not as best as it should, because it's not an issue that should come to the cluster. It's too operational for that purpose.
Yes, and I think there's no dispute between us that during those years there was a struggle to get investigative support. And I don't want to waste time going into the evidence that this commission has heard. But, there were attempts to appoint police officers. So for example, a letter has been distributed to us, I don't know whether it's on your table, from
I don't see a letter, no.
Assistant Commissioner Jacobs, dated 6th of December 2006, where he requests provincial commissioners to appoint 1 officer in those 5 regions. And yet, as far as we know, there's no evidence to suggest that they were appointed, and even if they had been appointed, whether they did any work. Because through the 2000s, with the evidence of advocates Ackerman, McAdam, and Mugger, that they struggled to get investigative support. And I suppose for us lay people, when a murder takes place down the road, or somebody is kidnapped, detectives and prosecutors don't normally go cap in hand to the DGs or to the ministers saying, we need support to investigate these cases. It happens in the normal course. And the question is, why shouldn't have this happened in the normal course?
Well, I'm not sure what between the police and the NPA happened, but after that meeting that we had in the West Wing, there was no issue again of lack of cooperation that was brought by the NPA to me as the DG, which I needed to take to the cluster. And for all intents and purposes, there would not have been an issue on which the cluster needed to intervene. So my role would have ended at that particular stage. Everything else would have been handled by those who were involved directly with it.
And in paragraph 54, you say that even if the DG is accepted and proceeded with the proposal, it would still have to be submitted to the ministers for them to note, to see if there were any aspects they wanted to contribute towards. It just sounds extraordinary that basic investigations into serious crimes have to jump through these hurdles all the way through to the ministers' cluster.
You're saying it sounds?
Yes, I'm making the point. I'm putting it to you. That
Yes.
it's extraordinary that where you have very serious crimes, particularly old ones that should be given some priority, as in these cases, that for support, it has to go up the chain of command, the DG's cluster, and as you point out in paragraph 54, it would still also have to go to the minister's cluster.
No, it happens on a daily basis on many matters. In this particular instance, I think we've discussed ad nauseum the nature of TRC matters and the necessity of consistent reporting. So the ministers would have really been informed for them to note that this is the kind of progress that is being made. That's all I'm indicating there. But in the normal course of events, if there are any matters, whether it's now I'm talking about non-TRC related matters, the need to deploy the military somewhere to provide capacity to the police, if there's an issue of youngsters involved with drugs in any location that requires specific attention, all of those issues the cluster as a normal program deals with. And those issues do get reported as far as cabinet, depending on what is required. Sometimes it may just be to note that there is a problem of Nyawope in Umlazi, for argument's sake. And as a result of that, this is what is happening around that area. That small, what appears small, does find itself to cabinet. So it's not extraordinary. That's how the system works. That's what I'm trying to say.
No, indeed, and I could certainly understand if one wanted to deploy the military and the expenditure of such resources that you would have to go up the chain of command. But here we're not talking about those kinds of resources or that kind of program. We're talking about individual murder cases. And actually, although the TRC referred a few hundred cases, the shortlist that the NPA came up with was quite small. I don't have the exact numbers in front of me. But of the cases that they wished to go ahead, it only numbered around 20 odd or thereabouts. So we're not talking about a massive expenditure here. Why did so few cases have to go up the political chain of command?
I'm not sure that that's accurate. As far as I'm aware, I don't recall any case that had to go up with political chain of command for it to be attended to. I mean, the matters were attended to, and I think if you recall the evidence of Chris McAdam, where at some point a docket was missing, it was found in 2010, they started working on it. Those things do happen in respect of all matters. Those matters don't necessarily get reported with that specificity upwards on the chain of command, even up to the cluster. What gets reported in general is whether progress is being made, how far it's being made, if there are any hurdles where the cluster needs to intervene. That's the kind of reporting I'm talking about. The cluster doesn't deal with too much operational matters unless an issue is being presented as an operational problem that the DGs are now required to resolve. Otherwise, at the level of joints, and interdepartmental task teams. That's where matters get resolved. The cluster is never that operational.
So I get the impression that you're suggesting that the delivery, the performance in respect of the TRC cases was adequate and satisfactory. Are you saying that?
No, not that it was adequate, no.
Are you saying that it was poor or inadequate?
No, I mean, for TRC matters, it wouldn't be adequate. The fact that we're here just demonstrates that it could never have been adequate. That's the problem.
Yes, indeed.
Yeah.
On that score, we're in agreement. All right, let's move on. Paragraphs 56 and 57, you point out that where there is no agreement in the cluster, in other words, a stalemate, I think is the word you used in paragraph 56, the cluster would then report to the ministers for their intervention. And then various departments, SS, I assume, is Secret Service, NEA, I suppose DHA is Department of Home Affairs. I'm not sure what DI is, but they would
Defense
then make their
Intelligence.
inputs.
Yes.
And if it wasn't possible to resolve it at the level of ministers, then what would be required is a formal memorandum to Cabinet. And you speak below about there'd be a joint Cabinet memorandum, which would have been discussed in the JCPS Cabinet Subcommittee first, and then on to the Cabinet. Now, in this case, there was a stalemate. There was an impasse that simply wasn't resolved. So did that escalation take place?
No, there was no stalemate. What I'm referring to there is that after the decision that was taken by Advocate Picoli to remove Mr. Ackerman, although it turns out it wasn't necessarily implemented. What I'm saying is that what was then expected is that cooperation between the police and the NPA on their own would continue and would happen, and the program would run ordinarily. But assuming that there was no agreement and therefore the problem continued, then the police would have put their proposal as the letter from the late National Commissioner sought to do. That kind of suggestion would have been discussed in the cluster to see if the cluster accepts it. If the cluster didn't accept it, that would be the end of it. But if the cluster did accept it, and it will then be implemented. But assuming there's a problem with it such that there is division within the cluster, the cluster, because it can't order departments to do things or to not do things. What the cluster would do and does do in the normal course is to simply report the matter to the ministers to say we have a problem in the cluster, despite deliberations we can't resolve it, and this is the nature of the problem, and these are the options that are in dispute, and ministers are requested to intervene. That's how it would be dealt with. That's all I'm simply indicating, how things would have progressed had issues not ended in that meeting.
Yes. Well, let's take the support of the SAPs, because in paragraph 57, you say that, at least as I recall, SAPs did not submit a proposal to the DG's cluster, and obviously the matter did not get onto the agenda. You say what you recall regarding how the meeting between the DGs and the NDPP ended, and the subsequent briefing to the ministers. And then you point out that there were other developments in the country, such as which affected the departments, Justice, SAPS, NEA, DI, and SS, such as the Khampepe Commission of Inquiry into the DSO, presumably, the Jinwala inquiry, and then the legislative process of the DSO. So it does seem as if, at least according to your knowledge, that question was never resolved.
Yes, as a proposal in that sense, it was never resolved. But also what didn't come back on the part of the NPA as it had come before was that they have a problem that they want attended to. So the issues almost just never came up again. And I think with the other things, I think everybody's attention then got distracted in that sense.
Okay, that wraps up your supplementary statement. There are just a couple of things arising from your testimony that I wish to canvass with you. So in your evidence in chief, and if I can draw to your attention in the transcript, pages 39 and 40, and that would be from page 645 of the bundle, and it starts at about line 20, which is towards the bottom, page 30. Use worse words, but I think it was deeply resentful. They literally wanted nothing to do with him, you know. In fact, there were times when I feared for him because one did not know what people would end up eventually doing, because the way they felt so strongly about an individual. And then you mentioned other names such as Dolavira, Ackerman, and McAdam. So are you saying that you actually feared for Ackerman's safety, just given the sentiments expressed?
Not really feared for his safety, but it would not have excluded one to wonder that with that level of resentment by people in that type of environment, because it's an environment of people that are trained with, in the manner that they are trained. So if they express the kind of resentment against an individual in meetings, still with restraint, yes. So you never know what else they discuss elsewhere. So there's always a concern in the security cluster when there are strongly held views about such things.
Yes, well, it does seem actually that you had a concern about his safety, because as you said, you never know what they could do.
Yeah, but I mean, it didn't get to the point where anybody needed to do anything about it, but it needed to be noted that it needed to be put to a stop at some point.
Now, earlier you spoke about trust. If I can refer you to page 48 of your transcript at the bottom of the page. You state that, so for me it was very clear, and in the way in which that grouping of people engaged, the trust was a central issue. If you were not trusted in any way, not even just with the task, if you're not trusted to be in the room, it is a problem. And actually, later in your evidence, you refer to that theme, the question of trust, and having somebody there who is trusted. Now, I want to put it to you that from the family's perspective, it seems that when you refer to trust, you're referring to a person who will do what's expected of him and who will do what the DG cluster requires of him. Isn't that ultimately what this is about?
No, that's completely incorrect. Completely incorrect. I mean, I don't even think the context suggests that kind of thing. That's not how the cluster worked. What I'm talking about there is that a security environment is such that although you are colleagues, I mean, you're not buddies, you're actually colleagues and you don't know each other more often than not. So if people are going to work and are going to agree about how they're going to work, it becomes important that they have the level of cooperation that is informed by them trusting that they will do their work as required. So even as DGs, I mean, we needed to trust each other to the level that we could engage quite freely and speak freely. Because sometimes it does happen that if people don't feel safe in a space, they just keep quiet or they don't engage in the manner that is helpful because of however they feel. So the task is to make sure that everybody feels safe enough to be able to do their job as best as they can. That's the trust I'm referring to.
Then let's move to the next page. And that's at it's about line 7 or 6. You mentioned that the only person that I could call or who could call me was Commissioner Celebby. Am I right in saying that you and Celebby, at least in relation to the TRC cases, were like-minded? You shared the same approach?
No. What I'm indicating there is that because we were co-chairs, we were required to generally keep tabs of the work of the cluster. So every time anybody would have needed to follow up on an issue of the cluster, they would go through either me or through him. So for example, the Secretary of Defense wouldn't necessarily call me.
Then if we can turn to the bottom of page 42 of your evidence in chief, you make reference to the national security standpoint and the fact that there were people, obviously the debate as well was that the people of the system they were describing were now within they were working with them, we were all in the same system. So those were in special branch were still there in the police. I suspect that the transcript didn't capture your precise wording, but I think what you were saying there was that one had to be careful because old order people were still in the system. For example, special branch individuals were still in the police. Is that roughly correct?
Yes, not just special branch and those who worked in the homeland governments were also there. So there was that general, in the same way that others said would have expected that those who came from the non-statutory forces were also integrated into the system. Those who were in the SDU, self-defense units, self-protection units, were integrated into the system, were there. So everybody, in a way, still functioned in a manner that people would want to be as comfortable as possible and as safe as possible because they didn't know who they were dealing with and what the background of that individual was or would have been.
Yes.
Yes.
Now, would it surprise you to hear that Advocate Ackerman actually shared those concerns? He was very concerned about working with police officers who were former security branch officers, and in fact, on at least one occasion, he objected to a certain police officer being involved in the TRC cases because he was a former security branch officer.
No, I had that in his evidence here in the proceedings, yes.
Yes.
So it wouldn't surprise me in the sense that everybody involved would be that aware, situationally aware. And I think it's quite telling that he himself was situationally aware, so which means he was quite alive to those kinds of issues from his experience.
Yes, but isn't that consistent with the various claims that were made against him?
Isn't it consistent with?
Consistent with the claims that he was, an apartheid-era prosecutor with dubious links?
So what would be consistent with that?
The fact that Advocate Ackerman objected to working with a police officer who was a former security branch officer
Yes.
on these cases.
Are you referring to Brits?
I am indeed referring to Brits, exactly.
Yes.
Yeah. So there was, I believe he was a senior superintendent, Brits, and he was the officer in question that Advocate Ackerman objected to.
Yeah, I don't know about how anybody felt about them. It was never brought during my time. All I'm simply saying that I understand why he would he would feel that way because it means he would have had knowledge just as much as others would feel similarly in that way with the knowledge they would have on others.
Okay, let's move on. So if I can direct your attention to page 78 of the transcript, in the bundle that's at page 684. And this deals in relation to your handling of the TRC cases. Well, you were I believe while you were NDPP, but let me just check. Yes, Advocate Masuku puts a paragraph to you about the case is being firmly frozen and asks whether you agree with it. And your explanation in disagreeing is because, and this is the top of page 78, because there was no matter that was presented to me by way of a report that said the matter is ready for prosecution, and it was never prosecuted. Secondly, no matter was brought to you that is ready for prosecution. I suppose that's duplication. In the reports that the different units gave or would have given that these matters remained under investigation. So while you were NDPP, all the matters were under investigation and no case was brought to you that was ready for prosecution. So the question is, did you ask your team why there were no matters ready for prosecution while you were NDPP?
No, I didn't have to, because in the reports they explained that matters are under investigation, and they would explain challenges that they would have encountered of this and the other. So I quite understood that despite those challenges, at least they were making an effort to going forward.
Then I want to refer you to a memorandum that was prepared by Advocate Mshare, and I believe that this is it a standard? Let's just find out where it is in the record. It's at page 717 of the bundle. It's in the supplementary bundle.
Yes, I have it.
You've got the document in question?
Yes, I do. Yes, thank you.
So it's addressed to the then Minister of Justice, Mr. Surti, from Advocate Mshare, the then acting NDPP, dated 17 February 2009. And the subject is TRC Task Team. In paragraph 1, you'll see that Advocate Mshare says the purpose of this memo is to inform the Minister of my intention to reconvene the TRC Task Team. To save time, I'm not going to go through it. He provides background and a briefing, and he sets out under the briefing on page 2, paragraph 3.4, 9 matters that he says are on hand at present. besides the case of Nokuthula Simelane, that's the one at 3.44, we've discussed that already, that the Simelane family had to go to court to get a decision there. But in the rest, and perhaps to be fair to you, we should identify them. 3.4.1 is the PEPCO 3 matter. Secondly, Anton Lebowski assassination. 3 is the Craddock 4. 5, Heidelberg Tavern and St. James Church. 6, Philip Powell. 7, Samora Michelle. 8, murder of Rick Turner. And 9, allegations against former General Barcy Smith. So besides the Nokuthula Simelane matter, are you aware of any of these cases going ahead?
I don't remember specifically if any matter went ahead, but I'm aware that they were being attended to. If you mean go ahead as in it started in court, enrolled, and the trial run.
Indeed.
No, not that I can recall.
Yes. Well, we can tell you that with PEPCO 3, sadly, that matter is only being heard as a reopened inquest in October this year, and there's only one surviving suspect in that matter. In Craddock 4, the majority of the suspects have passed on, and we're currently busy with a reopened inquest. But for the rest, we're not aware of any developments. But I want to draw your attention to the bottom of page 4, because there's a note there from yourself. And I think because it's your handwriting, you will probably be best to read it into the record tonight. Advocate Simelane, sometimes you write like a doctor. Could you just read that into the record so we're all on the same page?
Yeah, I'll try. It may be useful that the minister first discuss these matters with the IMC ministers so that the acting NDPP can be advised how to proceed, especially on what the mandate of the NPA is on these matters.
Thank you.
Are
If
there
at
words
all.
that follow?
If at all. I think
If
it's
at all, yes. So, why did you feel the need to write this note that that this must be raised with the minister first? He may then want to raise it with the IMC ministers. Is that the interministerial committee?
Yes, the interministerial committee, yes.
So that the acting NDPP could be advised on how to proceed, especially on what the mandate of the NPA is on these matters, if at all. Because again, it seems to us that you're suggesting that at a political level, the minister and possibly the IMC ministers need to advise the NDPP, the acting NDPP, on how to handle them.
Yes, it was for them to make their own comments, if there's anything they wanted to know. So in the same way that the cluster would report upwards for noting or for comment, that's what that note basically was suggesting to the minister or recommending to him.
But you agree there was no real need for the ministers to make comments on these matters and how they should be taken forward?
No, I don't agree. There's a need all the time for political leadership to comment on issues that affect the nation.
All right, finally, I want to put to you a sentence from the finding of the Jinwala Commission report about the referral of the handling of the TRC cases by then NDPP Picoli. Commissioners, this is in Bundle 1 at page 114, paragraph 281. and I'll just read this into the record and then seek your comment. This complaint also touches very closely on the constitutional guarantee of independence of the NPA to prosecute or not to prosecute, and to do so without fear, favour, or prejudice. Would you agree with the finding of the Ginwala Commission on that aspect, that the referral of the complaint of the TRC cases touches closely on the guarantee of independence of the NPA to prosecute or not?
Sir, we are reading on page 114, paragraph.
Okay, so it actually starts at the bottom of page 114, paragraph 281, and then the balance of the quote is at the top of page 115.
Yeah, which complaint is that?
The complaint is the referral by the government of the TRC cases, or the handling of Advocate Picoli of the TRC cases to the Ginwala Commission.
It's going to be difficult for me to explain that, because I'd have to understand what that complaint was, or what was alleged in that charge. I don't seem to recall the specificity of it and how it was framed. So I don't know, because I don't want to comment on something I haven't seen, because that comment that that finding that you've just read suggests that if there's the complaint by government in respect of TRC matters against Advocate Picoli touches very close on constitutional guarantees. Is that how you wanted to say?
Well, I'm quoting what the chairperson of that commission wrote in her finding, and you will recall that the various complaints that have been raised were also put before the Ginwala Commission. For example, that Advocate Picoli was insensitive in his handling of these cases, failed to consult, and the like.
Right.
And so that complaint was ultimately dropped during the course of the proceedings, but nonetheless, the Ginwala Commission was moved to make that finding, that the complaint itself touches on the independence of the NPA to prosecute or not.
I'd rather not comment on that aspect. Thank you.
No further questions, Chairperson.
Thank you, Mr. Vani. Mr. Semenya?
Thank you, Chair. Just perhaps a few questions. Might I invite you to go to page 722, that is in this bundle for cross-examination.
Bundle for cross-examination, 722.
722 at the top of the page.
Yes.
All right. What the reader of this document will see at the top is a coat of arms of the country, right?
Yes.
Also see that it is the office of the President of the Republic, yes?
Yes.
What they will also see when they look at the foot of the page, they will see that it is dated 24th of March 2003. Correct?
Yes.
It will also be obvious to the reader that this is a proclamation by the President of the Republic of South Africa. I must be right, hey?
Yes, that's the proclamation.
And it relates to the National Prosecuting Authority Act of 1998. But most importantly, the reader will see that it concerns the determination of powers, duties, and functions of a special director of public prosecutions. I'm reading it correctly, eh? I am reading it correctly. And it says under section 1301C of the National Prosecuting Authority Act, 1998, in parentheses it says what it says, hereby confer, impose, and assign the following powers, duties, and functions on or to Anton Rousseau Ackerman SC, as Special Director of Public Prosecutions, appointed in terms of the said provisions. So we do know this is an appointment letter for Advocate Anton Rousseau Ackerman to this as a Special Director, correct?
Yes.
It continues to say to exercise the powers, carry out the duties, and perform the functions necessary within the office of the National Director of Public Prosecutions as directed by the National Director, that to be the NDPP, right?
Yes.
And I want to emphasize what follows. In particular, to head the Priority Crimes Litigation Unit and to manage and direct the investigation and prosecutions of crimes contemplated in the implementation of the Rome Rome Statute. And it continues, but I want to deal with this. It is given the power to investigate, right? What is not stated in the letter is how that investigation is to be conducted, correct? Neither does it prescribe how the prosecution should be done, right?
Yes.
And then it says all of those, but it includes at the last line of that paragraph A, or such other priority crimes to be determined by the National Director. So we do know from this proclamation that the National Director can include in that list of other crimes described some other priority crimes, right?
Yes.
On record, we know that include that the TRC, that the NDPP included under the PCLU. You're familiar with it, aren't you?
Yes, I saw that on the record, yes.
And at the foot of the page, it is signed by the President as well as PM Maduna, who then was the Minister of Justice. Correct?
Yes, I see that.
I have placed before us, well, we as the evidence leaders, placed the document my learned colleague referred to a little earlier. And I want to suggest to you that it gives us a clue how investigators were ultimately to be procured for the purposes of dealing with these matters. It is that document, PCJ 18, that you are shown. Do you see that?
Yes.
Now, let's deal with this because I'm going to suggest ultimately it tells us how those investigators were to be procured. The insignia there is that of the SAPS, and it says so on the side of it. You agree?
Yes.
And we know it is in 2006, December, yeah? 6 December 2006. You agree?
Yes, that's the dates there.
Addressed to various provincial commissioners. You see that at the top, A, B, C, D, and E. Right?
That depicts that it's addressed to them. If that's what it is, yes, I see that.
Correct. And if you go over the page, you will find J.F. De Beer, who is the Divisional Commissioner, Detective Services. Right? We have had that evidence. But most importantly, it addresses all those provincial commissioners to say, I read from paragraph 2, you requested to make the following officers available as indicated from stroke against your province. Interdepartmental committee appointed to deal with these matters, and you know what those matters are because they're in the heading. The heading would tell us investigating officers to assist in the finalizing cases emanating from the TRC Commission, TRC. You see that?
Yes.
So the document in its own simple reading would tell us how those investigators were to be secured. You won't argue with that, would you?
Well, I don't know if these were the investigators that were contemplated in what was discussed in the cluster.
No. For what the letter is saying, I haven't changed its meaning, have I?
Well, I understood you to be putting to me that this document demonstrates how investigators were to be appointed.
No, I'm saying it says what it says, but we can now glean that the investigators for finalizing those matters, to assist in the finalizing of those matters, it relates to the TRC matters. The document says so. I don't think we should debate that. Correct?
Well, the document says what it says in the heading, yes, I agree with that.
Yes. Now, we, to date, do not know that there was ever an investigating officer for these TRC cases since 2006, December. That's a pretty long time. You'd concede that too, right?
You think there's never been an investigating officer since that time?
I'm saying the commission does not have any investigating officer under the PCLU at that time to up to 2021. I'll tell you what's the difference. You have no information to negate that proposition, right?
I'm not sure if I'm hearing you. To say,
I say,
I'm trying to understand, the commission, which is this commission,
yes,
right? You're saying this commission?
does not have information that indeed the PCLU did appoint an investigator, and I'll cover certain periods.
Okay,
You
I
have
don't
no
know
information to negate that, do you?
that. No, I don't know that.
Correct. Now, the points I'm making with you, and I want your concurrence if you can, is that without investigators, there would not have been progress in the investigation and prosecution of those matters. It follows by way of reasoning, I think.
Yes.
Okay. We see traction happening since 2021, but it's because of other factors. We know Advocate McAdam retires. You can take it as a given unless you know differently.
No, I don't know. I'm assuming you must have retired by now, yes.
And also what you might not know is that Advocate Singh gets involved in TRC cases, and some traction begins to happen after the departure of Advocate McAdam. You can't negative that information, can you?
No, I don't know. I wasn't in the NPA at the time.
And I'm making this because as the evidence leaders, we want to request certain factual findings to be done. That even during your period, you are not aware of any investigator for TRC cases at all, right?
No, I was not informed that there's an investigator appointed, yes.
Yes. You used the word, there were certain matters that were not prosecutable. You
So
recall
I
that?
used, beg your pardon?
There were matters that were not prosecutable, I think, some of these TRC cases.
I don't know, I didn't say
Oh,
that.
well, the context is you would find it in the transcript of your evidence. If you come with me to page 93,
93 of the,
of the transcript. Your evidence,
okay.
I think the date is the 26th of March this year, 31 March. Are you there?
Yes.
Just about line 11, you continue to say, so it goes back to my point that in my time that I was there, about 2 years in the MPA, there was no prosecutable matter that was ever presented to me by anybody. I would have said it must not go ahead. So, but you see that
Yes.
they become not prosecutable, at least in part because there are no investigations regarding those. Is it that a fair inference?
Not really, because as I indicated, the team was conducting the work of those investigations. Whether or not there was a specific individual appointed to investigate is something else. I'm not aware of that, but the reports that I received were that those matters were proceeding in terms of the NPA engaging the police.
And I won't contest that on paper that is what is given as a report to you. All I'm saying is, with the evidence collected by this commission, we are yet to see one single investigator appointed for the PCLU to discharge its mandate up to the leaving of Advocate McAdam in 2021. You have no information to gainsay that, I take it.
I can only speak for the period that I was there, yes.
There are no further questions. No further questions to
Thank you,
the
Mr.
witness.
Simon.
Just one follow-up, Mr. Similani, Advocate Similani. PCJ 18, the letter dated 6 December 2006. Now, this would have been during your time, addressed to the provincial commissioners about officers to be appointed. To your knowledge, were these officers actually appointed?
I don't know, I wouldn't know. I'm seeing this letter for the first time today. I'd not seen it before.
Okay, thank you.
Thank you.
Mr. Masugu?
Thank you. Thank you, Chair. Thank you, Commissioners. I have a few re-examination questions. And Mr. Smelane, I'll focus mainly on the issue, on the interference questions. And they will arise from your understanding of the allegation that the work of the cluster, the DG cluster, the cluster, and some of the DGs, and you can comment on whether the executive, the members of the executive were also involved in it. In terms of your understanding of interference with the work of the NPA or prosecutorial independence, you would accept that such an allegation would have been very serious in light of Section 32 of the NPA Act. Would you agree with that?
Yes.
Because that Section 32 specifically says that, if I may just read it. Oh my gosh, I had it with me here. Yeah, thank you. Right, Section 32(1) B says, subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of his or her powers, duties, and functions. You recall that section?
Yes.
And then the penalty for this contravention of Section 32, 1B, is set out in Section 41 of the NPA Act. I will just read it. Any person who contravenes the provisions of Section 32, 1B shall be guilty of an offense and liable on conviction to a fine or to imprisonment for a period not exceeding 10 years, or to both such fine and imprisonment. You recall that?
Yes, vividly, yes.
Now, so if there are good faith allegations that a particular official of an organ of state, particular officials of the organ of state, are interfering with prosecutorial independence in the sense provided for in Section 32, 1B, they would be essentially committing a crime that is punishable under Section 41. Am I correct?
Yes.
And you would accept that there would be a duty on a prosecutor or the NDPP to act if such interference takes place, and to point out that this interference is in fact a criminal offense. Would that be your understanding as well?
Yes, they'll be entitled to do that.
Right. But to your knowledge, there were certain DGs, and this is something that has almost become common cause. Certain DGs expressed views about Ackerman and his position as the leader of the TRC prosecutions. You recall that?
Yes, I do recall.
And as you testified, some of them expressed very strong views about Ackerman being the face of the leadership. You recall that?
Yes, being the face of TRC
cases,
yes.
yeah. When that was brought to the attention of the NDPP at the time, the NDPP disagreed with those views, suggestions, or opinions of those DGs. Is that correct?
Yes, it did disagree.
Now, what would you say about an allegation that suggests that that disagreement that they had, or that disagreement, or that their views and their position in relation to Mr. Ackerman amounted to interference in terms of Section 32, 1B?
Well, I think if the view was strongly held in that way, one of the options available was to make it known to those individuals that their conduct is being experienced in that particular manner, so that if there's any misunderstanding, that's corrected. Or if it is still not corrected, despite it being explained, then they would have been entitled to be charged and prosecuted for that.
Right. And if a prosecutor feels very strongly about the nature of the conduct that constitutes a contravention of Section 32, 1B, they would have to exercise their powers to bring a charge against that person interfering, right?
Yes.
Because I'm sure you accept that interference in terms of Section 32 of the NPA Act requires more than just engagement in disagreements, right?
Yes, yes.
it requires improper influence over a decision-making process, right?
Correct.
Now, can I then ask the following questions? You've not been confronted, and if you have, please point that out. You've not been confronted with evidence that either yourself as a DG or other DGs acting within the cluster instructed the NDPP to initiate, withdraw, or reverse a prosecution. Have you been confronted with such facts?
No.
Have you been referred to a document or evidence from the DG, from the cluster, or from yourself as DG at the time, instructing Mr. Advocate Ackerman or Mark Adams or any prosecutor, including the NDPP, to initiate or withdraw or reverse a prosecution?
No, I've not.
Now, to the extent that there was a collaborative approach which involved certain bureaucrats in the form of DGs expressing their views or their opinions or recommendations to the NDPP, I want to take you to Section 22 of the NPA Act. And I'd like your comment on that. That section provides the following. Section 22 deals with the powers, duties, and functions of the National Director. And it says the National Director, as the head of the Prosecution Authority, shall have the authority over the exercise of all the powers, performance of all the duties and functions conferred or imposed on or assigned to any member of the Prosecuting Authority by the Constitution, this Act, or any other law. And I want to go to subsection 4, which says, in addition to any other powers, duties, or functions conferred or imposed or assigned to the National Director by Section 179 or any other provision of the Constitution, this Act, or any other law, the National Director is head of the Prosecuting Authority. And you can go to subparagraph C. So it would be Section 22, 4C, which says that may consider such recommendations, suggestions, and requests concerning the prosecuting authority as he or she may receive from any source. You see that? Or you hear that?
Yes, I do hear it.
Right. So, seems to me, if one were to look at that provision of the NPA Act, it was not an act of interference as provided for in Section 32, 1B, when the relevant stakeholders in government, such as the Director Generals and the cluster, were expressing recommendations, suggestions, or requests concerning the prosecuting authority that were received by the NDPP. Would you accept that?
I would accept that.
That the recommendations or the comments or the views of even the actions of the Directors Generals that you spoke about,
Yes.
in relation to the NPA and their engagement with the National Director of Public Prosecution at the time,
Yes.
would fall under the protection of Section 22, 4C, which says that the NDPP may consider such recommendations, suggestions, and requests concerning the prosecution authority as he or she may receive from any source.
Amongst others, yes.
Yes. So you'd accept that there is no prohibition against the NDPP receiving any recommendations, any suggestions from any source, including the NDPP, and including the Director Generals and the cluster.
Yes, no, there wouldn't be. It was already happening with the interdepartmental task team anyway.
Now, to your knowledge, as a Director General, I think you've already testified on that, and I think I'll after posing the question, I'll probably require a yes or no answer. Were there any allegations brought to you as a Director General or as NTPP by Mr. Ackerman, Mr. McAdams, or indeed any prosecutor in the PLC, or indeed while we were DG by the NTPP, that they addressed to you about interference in their work?
No, they also wouldn't have come to me in any event because as DG I would have nothing to do with prosecutorial matters.
Yes, but I mean, to the extent that they believe that you were interfering with the work,
No, nothing was brought to me.
nothing was brought to you. Now, it was put to you at some point, during cross-examination by my learned friend, Mr. Vani, that the complaints about Mr. Ackerman had no factual backing. You recall that?
Yes.
That the views that were expressed about him did not refer to specifics. It was very just general, based on Mr. Ackerman's history as a prosecutor under the apartheid government, the apartheid state. You recall that?
Yes.
Right. If I were to refer you to Reverend Chikani's complaint about his case and the manner it was handled, would you not regard that complaint? You recall that complaint of Reverend Chikani?
Yes, I recall that he was unhappy about how he was treated by the PCLU.
Right. Would you not consider that to have been evidence that pointed to a very major victim, or one of the victims of the direct victims of the apartheid crimes, that related to the conduct of Mr. Ackerman in the prosecution of a case directly relevant to him?
Yes, it's something that would be of extreme concern to the cluster, because the idea would have been if a victim of the type of conduct against him complained about the manner in which a structure designed to attend to those matters was doing, it would be inimical to what is expected. And the concern would be, if there's one matter of the type, it would be key to ensure that it's not something that gets repeated in other matters.
Right.
So when somebody complains, it does become a concern.
Yes. And then the last issue relates to a question put to you regarding the prosecutions of the TRC, the nature of the TRC cases, and why those prosecutions required a particular way of handling. If you recall, the allegation put to you was that why was it necessary for DGs to be concerned about these particular TRC cases? Why shouldn't they have been prosecuted as normal cases? And they were called very serious cases. And indeed, they were serious cases. You recall that question?
Yes.
Right. And your answer was that, look, I mean, the nature of the cases was such that, you know, they had to fit into a national discourse on reconciliation and just dealing with the past in the best way the country could. But I want to ask another question that could aid your answer that you gave, which relates to the sentences that you're aware of cases that went through the case. One case of Blani, the case of Blani, who committed a murder of 2 people. That person got an imprisonment sentence that was suspended. Would that be normal in a prosecution? I mean, a murder of 2 people, and they get a suspended sentence of a suspended prison sentence. Would that be normal in a normal prosecution?
It will raise eyebrows Why? Especially if it's a plea and sentence arrangement. But I mean, each case would depend on its facts, but there would certainly be something asked about that.
Yes, but people would understand that the TRC cases are a little symbolic in the sense that, you know, you're not looking for a concomitant, that word, Chair, concomitant, yes, a sentence in the sense of the crime was murder and the sentence must meet the gravity of the crime. And if you look at the conviction of the apartheid operatives who poisoned Reverend Chikani and attempted to murder him, the sentence there was also a prison sentence which was suspended. You recall that?
Yes.
And that was acceptable in a way because of the nature of the TRC cases. Is that not correct?
Yes, it should be it was accepted for that reason, but also informed by the views of the victim in that sense.
So the allegation that was put to you that these are really serious crimes, and why was the prosecution system activated to deal with these crimes normally misses the point you're raising about the nature of the TRC cases. Is that not correct?
Yes, it's correct. They're not the same. They couldn't be
Chair,
treated the same.
those would be the cross-examination, sorry, the re-examination questions. Oh, sorry, before I do that, let me ask. That would be all. Thank you.
Thank you, Mr. Masuku. Mr. Simelani,
Yes,
we thank you once more for having agreed to come and give evidence before this commission. You are now excused as a witness.
thank you.
These proceedings are adjourned until the 7th of May 2026 at 10 hours.